What is it?
2021 matters. This case is posted for admission. The widow is suffering from financial difficulties to lead her life. Kindly.
Add that to the list. Yes.
An MFA, my lord, it was to be listed after the service of summons. The other side have filed Wakalat. The petition is under
Next week. Yes.
My lords, pensioner, the interim maintenance have been awarded against the pensioner, my lords, and the maintenance amount is quite high. Therefore,
Which
I'll
year is
justify.
that?
my lords,
Which year is that?
2024 month.
Yes. Next week.
My lord, DNWC, my lord, interim custody is rejected to the mother. Meanwhile, she was summoned by the school that the child needs counseling and is undergoing some stress. And we have filed for weekend custody before the trial court. The trial court is not proceeding because the interim custody was previously rejected by the predecessor. Hence, may I request for, please,
Yes.
grateful, ma'am.
My lord, for extension of interim order, my lord. It is RPFC for extension of interim order.
What extension of interim order?
Actually, petition was dismissed for non-prosecution.
Hmm.
It has been restored, but the interim order has not been extended. Based on that, my lord, the respondent has filed
Tomorrow.
petition before.
Tomorrow. Yes. Yes.
MFA of the year 2023, my lords, the appellants are the Education Council. We are not able to conduct meetings as per the order of the lower court, my lords. Kindly.
Thursday, next Thursday. Yes.
Fresh matter,
26.
custody petition, the
No,
father.
The office objections are complete. It will come tomorrow.
Office objections, they're not scrutinizing only because there is no memo.
How
Because
can it be? Why? No, it is
though it has
something.
been said that
No,
it's a-
no. Why the court should tell them to, so even for scrutiny also. they
they'll
need-
take their own time because this is filed more than 4 days back, but they have not done the scrutiny.
Hmm. But it is not, how can they have to do it? No. Can't they do on a day wise, it has to be, no? Fresh matters have to be completed.
But all are certified copies,
Yes,
they will not be
yes.
grateful.
Lordship, there's an NBW and FLW issued against the petitioner. The police are after the petitioner for the.
Tomorrow, yes.
Family court matter, interim order was granted by this honorable court, but the same has been vacated due to a delay in payment, my lord. For the execution, the trial court will be taking.
When was the stay vacated?
Stay was vacated, it was a conditional stay, my lord. 4 weeks of time was granted from the date of 25th 4
When was
2024.
it?
By June, my lord.
Where are we now?
My lord, the payment was not being done, but in July, the arrears were made. The payment towards arrears of the amount rupees 70,000.
What are you doing? Question is, what are you doing from July and what is urgency right now?
Right now is that, my lord, they are going to take
Whenever the
steps.
NBWs are issued, then only you will pursue the matter.
Apologies, my lord, payment were made
But
late.
apologies, it is about the conduct of your client and why the court should accommodate him.
My lord,
Okay, tomorrow, yes, call the list.
So one is for hearing. So the year 2018, Railway Claim Tribunal, it was rejected. Now it is covered by judgment. Both are similar matter.
Monday, how many matters are?
Monday, there are 36 days, 36.
Tuesday? Tuesday,
29, Wednesday, 15,
take that.
15.
Yes, page wise mentioned.
Page wise adjournment, list 1, page 1, cell number 1 to 4. Page 2, cell number 5 to 11. Page 3, cell number 12 to 15. Page 4, cell number 16 to
Serial number
19.
16, my lord. The advocate relatives was no more.
Advocate?
Relatives was no more, my lord, and next week. I appear for the respondent.
Advocate for the appellant.
Relatives of the advocate for the appellant.
Oh, you're seeking adjournment on it is submitted, it's an MFA of 2017. It's submitted that the council has some personal inconvenience. Pose this matter when
Next week.
you let it come after vacation, please. After vacation on 23rd of October.
Please. Much obliged.
Yes, interim order is there?
No.
No interim order? Yes.
Your Lordship,
Page number
Lordship, CL number 18, Your Lordship.
Hmm.
Appealing for the appellant, I've informed the other side. There's a trial court, Your Lordship, the order 7, rule 11 applications for orders day after tomorrow. So kindly have the matter.
17 matters, because he said that it is some, for something, some emergency in the family. Otherwise, no 17 matters will not
Lordship,
be
my
adjourned.
only request is, Lordship,
Whatever reason.
there's a
Yes.
bearing of a writ petition order on this matter.
Why should a 2017 MFA be pending? We'll see. No, it is not, this business will not, it can't continue. Like MFA is pending on that ground, we'll hear it, we'll dispose it off today. Yes.
page
No, please don't make mentions about any of 17, 18 matters. Will not adjourn the matter at any cost. Yes.
Page number 5, serial number 22. Page 6.
Lordship, serial number 22, my lords.
Yes.
In this matter, my lords, the appellant number 1 has died 2 weeks ago. In view of that, I'll take steps necessary to. 22.
You submitted that the appellant is no more and for taking steps, poses matter after vacation on 15th of October.
Appellant number 1, my lords.
Appellant number 1.
One.
Yes.
Much obliged.
Serial number, page number 7. Serial number 24. Page 8, serial number 25 to 30. Page 9, 31 to 37.
Serial number 32, my lords.
Yes.
My lords, in this case, the respondent has filed the caveat subsequent to me filing the petition, my lord.
Yes.
And the respondent counsel has requested me to survey copies so that even he will present his argument, my lord. If your lordship is intending to grant time, it may be taken on Tuesday. Otherwise, I am ready to present my argument, my lords.
Yes. Pose this matter next week. At the
My
request
lord,
of-
may I request for it
of the
Tuesday? my-
respondent.
30, I appear for the petitioner.
32, I'm talking, my
He
lords.
is referring to 32.
32.
Yes,
Sorry.
at the request of the council. the
My
appellant.
lords, may I have a date, my lords? Can it be on Tuesday, my lords? I would request, my lord.
30th.
Highly obliged, my lords.
Yes.
Serial number
33 maybe have it on next week.
30?
33, my lord.
MB 10.
First time matter is listed, my lord. Today is having an appointment with the doctor, my lord, in the.
When he wants.
Any time. In the court.
Pose this matter on 26th.
Grateful.
Yes.
Serial number, page number 10. Serial number 38 to 43. Serial number, page number 11, 44 to 48. Page number 12, 49, page 2, list number 2, page 1, serial number 1 and 2, page 2, 3 to 8, page 3, 9 to 12.
Lordship, serial number 22, interim order has to be extended, my lords. The matter has been adjourned. I mentioned
page
interim order
4,
is there.
serial
22.
Interim order, wherever interim order is there. Yes.
Serial number
Page one.
32, my lord. I'm sorry, serial number 32, my lord. I have not yet received the copy, my lord.
For that you have to wait so that he will come and give you.
Please.
Yes.
Page, list number 1, page 1, serial number 1, parted matter, Kekar LS for appellant, Ninge Gowda for Kevita respondent.
Yes.
Defendant's appeal
Why is it adjourned on the last occasion?
was heard in part.
Hmm.
When he was about to all make submissions, it was adjourned.
Yes.
The suit is for declaration, injunction, and also seeking cancellation of the sale deed. As on the date of filing the suit scheduled properties was standing in the name of defendant 1 and 2.
Hmm.
This defendants 1 and 2 could get into the revenue records only after litigation for nearly 20 years. When their father made applications, it was objected by a third party. Thereafter, he files a suit in 2004. And when father dies, when we make application, defendant 1 and 2, again the same person files another suit against us in 2014. In 2014 suit, he will file an application under 7 Rule 10, take the plaintiff back, he does not file a suit. He instigates these defendants, plaintiffs, to come up with a present suit. There is a sale deed executed on 11/12. 10 days thereafter, the present suit is filed. The
Yes.
only intention is this. They don't want the revenue records to be changed.
Hmm.
They will institute a suit. They
Hmm.
will give the OS number to the revenue authorities.
Hmm.
The property will never be mutated. So taking advantage of this, the present suit has been filed. The trial court says the defendants are, plaintiffs are claiming under, the lordship may kindly come to. Paragraph 10 of the impugned order.
Yes.
As observed above, plaintiffs have relied on sale deed dated 1936, said to have been executed in favor of grandfather Chuda, alias Chude Gowda, son of Kumme Gowda. Defendant number 5 has relied upon a sale deed dated 27/3/1936 to claim the great grandfather of defendants 1 and 2 by name Chude Gowda purchased the suit scheduled property. On perusal of the records, it is clear that the defendant number 5 has not produced the sale deed dated so and so. They have produced certified copy of the sale deed dated 15/5/1936 pertaining to survey number 89/1, whereas the suit scheduled property is bearing survey number 79 and the same is mentioned as sale deed number 31/1936. Now, for a moment, your lordship may kindly look into the written statement. I have produced it. Giving a translated version, it is in Kannada. Nowhere we have made any claim regarding that our property is 89/1. All the documents what we have produced is pertaining to the earlier documents what has been produced by the person who has been opposing us for the mutation entry changes. He was having
What is no, both of you claiming title to the property from that.
one Bhadragiri.
Oh, what is the relationship of Badagiri?
I will explain.
Yes.
Our grandfather is Bhadragiri. My case is that one Chude Gowda, he purchased the property. He had a
1936.
that is in the year 1936. He had a son called as Bhadragiri.
Hmm.
He had a son called as Chude Gowda and 3 daughters. 3 daughters are dead. So Chude Gowda had 2 daughters and a son. Son died unmarried. Defendant 1 and 2 are the 2 daughters of Chude Gowda.
Hmm.
So when after the death of Bhadragiri, that is our father Chude Gowda made efforts to get the property mutated.
Hmm.
The Kunya Gowda of the same village,
Hmm.
he goes to the revenue authorities and files
What
objection.
is the relation of this?
They are in
plaintiff?
no way related to us.
Hmm,
They are outsiders to our family.
hmm. What did they say in the plaint about their relationship?
They are saying that one Chude Gowda he purchased a property. He had a son Bhadragiri. That son Bhadragiri had another son called as Chude Gowda. He is the husband of the plaintiff and other father of the other plaintiffs. First plaintiff and father of other plaintiff.
Even
That is father-in-law.
according to you also, Chude Gowda has a son,
Chude Gowda is my grandfather.
grandfather. Bhadragiri is his son.
Yes.
And Bhadragiri's son's name is again Chude Gowda.
Yes.
And he is your father. According to them, the defendant, it is her husband.
It is father-in-law. Bhadragiri is their father-in-law.
Correct. She said Chude Gowda, plaintiff's husband is Chude Gowda.
Yes.
And your father is Chude Gowda.
Yes.
So both of you are claiming through that Chude Gowda.
To Chude Gowda only.
Hmm.
But Bhadragiri is our grandfather. He is in no way related to them.
No, that has to be established now.
That has to be established. But as on the date of filing the suit,
What was the order granted? Not to alienate.
not to alienate.
Hmm.
Now,
So that is a tribal issue.
now for 20 years, right from 2004, we have been litigating with the said Kunne Gowda. All these
Who is
years,
that?
Huh?
With whom you are litigating?
one Kunne Gowda.
Who is Kunne Gowda?
He is also a resident of the same village. We have been litigating for 20 years. All these
Not
20,
related to
please,
both the
please,
parties.
please, now Mukti.
Here you will hear. Yes.
For all these 20 years, they remain silent. They remain silent spectator.
No, in
With
the
struggle,
revenue-
with struggle.
in the 1 minute, in the revenue records, whose name is there till 2020?
2020, it was still Bhadragiri's name was there.
Who is, according to both of you, according to you, he is your grandfather.
please.
According to her, it is her
Father-in-law.
father-in-law. Then when the mutation, the revenue entries were changed,
It was in the year 2021,
in whose name? In your name?
in my name,
Hmm.
in my name.
Hmm.
Thereafter, we alienated after 2 years. When
When did you alienate the property?
on 11/12/2023,
When was the suit filed?
suit is filed after 10 days. That is on 20/12/23.
20?
12,
Hmm.
2023.
Hmm.
For 20 long years, they remain spectators. They are,
The question, why should we take it as spectators?
1 minute.
Because it is Bhadragiri's name is
We
there.
are in possession, we are enjoying the property. Only thing is revenue record is not standing. It is like this, in a given village, there will be several people with the common name. It is like too many Ahmads in one village. Maybe in that village, there are too many Bhadragiris. That doesn't mean that they can make a claim by filing a.
Let's please come to the order now. Come to the reasoning part.
According to plaintiffs, para 7,
Yes.
according to plaintiffs, they are absolute owners and in possession of the suit scheduled property having inherited from their predecessor Chuda, alias Chude Gowda, son of Kume Gowda, as per sale deed dated so and so. That is 31/1936. It is alleged that the defendants 1 and 2 have no manner of right, title, or interest or possession over the suit scheduled property, but they illegally got entered their name in the revenue records and had sold the same in favor of defendant number 5. And it is alleged that now defendant number 5 is making an attempt to alienate the suit scheduled property. The plaintiffs, in order to substantiate their assertion, have produced with family genealogy, death certificate of Chude Gowda, alias Doddanna, alias son of Bhadragiri, alias Bhadragiri Gowda. RTCs of the suit scheduled property, certified copy of the sale deed dated so and so, certified copy of the sale deed 11/12/2023. On the other hand, defendants 1 and 2 claim that the suit scheduled property belonged to their grandfather by name Chude Gowda, and he had purchased the same under the sale deed 27/3/1936. And after his death, Bhadragiri was in possession and enjoyment of the suit scheduled property. Thereafter, his son Chude Gowda alias Kenche Gowda become the owner, and now they are in possession and enjoyment of the same. It is stated that the defendants 1 and 2, being the absolute owners, have validly sold the suit scheduled property in favor of defendant number 5, as per the sale deed dated 11/12/2023.
I've seen the order.
Please. Now, for so many years, we have been litigating and protecting our right, title and interest. These people, they do not do anything because they are not in possession. Here, I would like to pass on a judgment of the Honorable Supreme Court
Yes, please pass on.
regarding the equity. Lordship may kindly come to
Yes.
paragraph 21, page 8.
Yes.
While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, namely existence of prima facie case, balance of convenience and irreparable injury. It must also take into consideration the conduct of the parties. Grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with the properties exclusively, ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is very valuable one. We are not, however, obvious the fact that the grant or refusal of injunction was serious consequence depending upon the nature thereof. The courts dealing with such matters must make all endeavors to protect the interest of the parties. For the said purpose, application of mind of the courts is imperative. Contentions raised by the parties must be determined objectively.
Yes.
Yeah, for so many years, we have been fighting before the court and nothing is done. If they were in possession, if they had title to the property, they also would have come to the revenue of the courts and they would have protested. They would have filed objection. Nothing is done because we are in possession through our grandfather and we have protected our title and possession all these years. Only revenue entries were not there and revenue entries were made. Thereafter, we alienated being the daughters.
Yes, we'll ask.
Now, again, for a moment, your lordship may kindly come to the impugned application. It is in page 33. 33 to 35 is the application.
Yes.
Now, page 36 is the affidavit. Your lordship may kindly come to page 39. This is the affidavit I am referring to. This affidavit does not contain any verification. We all know that the affidavit plays a very important role while dealing with an application under Order 39, Rule 1 and 2. What is the importance of a verification in the affidavit when it is safe for the courts to act upon? I am passing on a judgment of the Constitution Bench of the Supreme Court.
Have you taken such a plea before the trial court?
But contention, I don't know whether it was taken or not. But anyway, I'm just passing on the material so that
No, that you should have taken it, you should have given, there must be an opportunity to the court to deal with it. We are not dealing with the original application
please,
now before this court.
please, I do agree, but I don't know whether my learned friend. in the
No,
trial
that
court-
is there, that would have been there in your objection. Where
No,
is your
objections,
objection?
statement of objections were not filed. A memo was filed to take the
Adopting the written statement of
adopting
the
the
same,
written statement. This is what regularly happens in the mafusil courts. And so this probably wouldn't have come before the,
No, particularly when an injunction petition, you cannot just like that adopt the written statement. For
I-
that, there should be an
I do
objection.
agree with your lordship, but that
Yes.
is a practice that is being made. Now,
Yes.
your lordship may kindly come to paragraph 11.
Yes. Yes.
The appellant made against Chief Minister so and so, whose names were disclosed and some of the names were not disclosed. Neither the Chief Minister nor the so and so was made a party. Appellant filed an affidavit in support of the petition. Neither the petition nor the affidavit was verified. Affidavits which were filed in answer to the appellant's petitioner were not also appellant's petition were also not verified. The reasons for verification of affidavits are to enable the court to find out which fact can be said to be proved on affidavit evidence of rival parties. Allegations may be true to knowledge or allegations may be true to the information received from persons or allegations may be based on records. Importance of verification is to test the genuineness and authenticity of the allegations and also make deponent responsible for the allegations. In essence, the verification is required to enable the court to find out as to whether it will be safe to act on such affidavit evidence. In the present case, affidavits of all parties suffer from the mischief funds. Even here,
Yes.
there is no verification and the court was not correct in acting upon such an affidavit and pass the impugned order.
Yes.
My lord, kindly see. The appellant
No.
has filed.
They say that the defendants are the daughters of so-and-so Gowda. So your wife you are claiming that you are wife of so-and-so.
Yes.
So what is the relationship between both of you?
No, there is no relationship in between the plaintiff and the defendants.
Hmm.
And my lord, kindly, I will take your honor my lord notice to the reasoning pair of 10. 10,
Yes.
internal page 9, para 10. As observed above, plaintiffs have relied upon the sale deed dated 31/1936, said to have been executed in favor of their grandfather Chuda alias Chudegowda, son of Kumegowda. Defendant number 5 has relied upon the sale deed dated 27/3/1936 to claim that great grandfather of the defendant number 1 and 2 by name Chudegowda purchased the suit property. On perusal of the records, it is clear that defendant number 5 has not produced the said sale deed dated 27/3/1936. They have produced the certified copy of the sale deed dated 15/5/1936 pertains to the survey number 89/1. Whereas the suit scheduled property is bearing survey number 79 and same is mentioned in the sale deed dated 31/1936 relied upon by the plaintiffs. My lord, kindly see, they pleaded one thing, they are arguing one thing. And moreover, they produced the sale deed before the honorable trial court, according to which they purchased the property from one Chudegowda, son of Kalla Gatti Chudegowda. But whereas they produced the sale deed dated 27/3/1936, in which it is says that
No, no,
Chuda,
they have
son of
not-
Veerbhadra.
The observation of the court is that they have not produced the sale deed dated 27/3/1936.
Yes,
They have produced the certified copy of the sale deed dated,
15/5/1936.
which is not tallying with the suit schedule.
Yes,
property. That's
and
fine.
another thing, 89, sir, they are claiming 89/1. Whereas our claim as per the sale deed dated 31/1936 is 79. So completely the property is entirely different. And moreover, what my learned friend canvassing that Kunnegowda has filed 2 suits, there is not, that suits are nothing to do with the dispute in between the appellant and the defendant. So
Yes.
because they are strangers, utterly strangers, they may file number of suits against this appellant. What shall I do for that? I am not made as a party in those OS. How can I expect this suit has been filed by some Kunnegowda against this person? I require to appear before the case and defend the case. There no notice has been served upon me by the trial court. So taking that aspect into consideration, that suits are nothing to do with this present suit.
Yes.
And this this reasoning paras of the honorable trial court
Yes,
is
yes.
foolproof. And moreover, other than that, Your Honor, that this defendant great grandfather Chudegowda purchased the property on 27/3/1906 from Chudegowda, son of Kallagatti Chudegowda. This is wrong as per the sale deed produced by them. This property has been purchased by Chudegowda, resident of Putta Egde Valse,
Chuda son of Veerabhadra of Putta
Where from you're submitting all this?
My lord, they produced the sale deed before the
Ask on
trial court. This is not typed sale deed.
That's
my
in
lord.
Kannada.
Yes.
May I make a submission regarding this? That is the reason I passed on the translated version of the written statement. Nowhere we have pleaded a case that
Not you have stated, but the sale
what
deed.
are the documents which has been produced
No,
that
no.
are bundled.
Please tell the court, you have produced the sale deed dated 15/5/1936.
This is the sale deed. These entire set of documents, what has been produced by me before the trial court is the documents which was produced by the other person who was litigating earlier in the proceedings.
You were saying about your source of title. Your source of title is a document dated 15, according to you, it is 27/3/1936.
Please,
You have not produced that, but
Please.
you have produced 15/5/1936.
Please.
Court gives a finding that it is nothing to do with the suit scheduled properties.
please.
So what is
That
the
is
other
the reason.
document?
What we have pleaded before the court can be looked into only from the written statement filed. Why these documents were filed? That is pleaded in detail in the written statement. In paragraph 9,
Why did you produce this 15/5/1936?
because we
sale deed?
wanted to convey to the court that we are in possession, we have been protecting our possession from other litigations, whether it is by the civil court or from the revenue authorities. This is what we wanted to bring it to the notice of the court. For that purpose.
Please
this-
understand the court's query and answer. 15/5/1936, is it the document according to you, your great
I
grandfather?
am not claiming the title under that document.
Then which document you are claiming?
The document which has been certified copy, which has been produced by the different plaintiff.
What is the date of
The
it?
same sale deed even I have to
No, your
produce.
pleading is the court says that.
Same sale deed, I am claiming under the same
Let's,
sale
let's
deed.
look at your written statement. Please come to the written statement.
Please. In the first paragraph, we have disputed the relationship, the genealogical tree, what has the second paragraph.
No, they are relying on a document dated 31/1936.
It is
You-
our document. It is our grandfather.
Please look at
Please.
your written statement. Don't be
Please.
so hasty in answering the court.
Please,
You,
There are
please
two,
come to
very
paragraph
clear.
3.
please. Defendants,
Please read.
defendants 1 and 2 and 5 further submitted the great grandfather of the defendant 1 and 2 is Chude Gowda. He had purchased the suit scheduled property on 27/3/1936.
Pausing there. You say that the same document, what he is relying on, you're relying on. That's not correct. What he is relying on is 31/1936 document. Yours is 27/3/1936 document. How can it be one and the same?
But I have to check whether the rate or date of registration may be for what is being mentioned there.
That can be done in the trial. Please come.
Now, and moreover, my lord, another important fact is the plaintiff has filed this suit for declaration and injunction,
Now,
not
one
for
more-
possession. We are in possession of the scheduled property. For that
For a
reason, we have
moment,
not.
for a moment, I
claimed the
may be, I
possession.
may be permitted. Your lordship may kindly look into the valuation slip. They are also not in possession. They have valued the suit for declaration and possession. Your lordship may kindly look into the valuation slip. It is
No, it has to
in
be
page
considered in
page
a trial.
31. In page 31.
Has to be adjudicated in trial.
This is not an injunction that's granted by the court. It's only a stay of alienation.
It's only regarding
Not to
alienation.
interfere.
It is not to interfere. It is
Yes.
regarding alienation. Why I am challenging this
Yes,
is
yes.
because of this order, being a purchaser, defendant number 5 cannot go to the banks and pledge the same. They cannot execute any documents.
You say that they've asked for recovery of possession. Where is it?
Or they have not asked for possession,
Hmm.
but valuation slip. If they were seeking only declaration, they wouldn't have valued the suit under 24A. Declaration and possession they are seeking.
Yes. Agreed with the orders passed. Line number 1. invoice number 968 of 2023, dated 25th June 2024. The defendants are before this court. What has happened to this? Oh, no, it will happen with this. The respondent herein, who is a plaintiff in the suit, has filed the suit seeking declaration and permanent injunction. It is a specific case of the plaintiff that one Chuda alias Chude Gowda, son of Ume Gowda, is a proposed. He and his wife Parvatama are no more, and their only son is Bhadragiri alias Bhadragiri Gowda. And they have one son by name Chude Gowda alias Doddanna. The plaintiffs are the wife and children of said Chude Gowda. It is their case that the Chude Gowda, son of Ume Gowda, through register sale dated 31/1936, had purchased a property and the plaintiff wife and children of Chude Gowda, who are the great grandsons of Chude Gowda, have inherited the property and they have been in possession of the property. It is their case that the defendants who are not having having no manner of title or interest nor possession or any portion of the suit scheduled property, where when they tried to interfere with their possession and started interfering with their possession and enjoyment of the property. Thereafter, they have obtained the RTCs and noticed that till 2019-20, Khata continued in the name of Bhadragiri alias Bhadragiri, who is none other than the father-in-law of plaintiff number 1, paternal grandfather of plaintiffs 2 and 5. And all of a sudden, from 2020-2021 onwards, name of defendants 1 and 2 is entered in the revenue records. The defendants 1 and 2 taking an undue advantage of the slight similarity in the name of the propositors, Chuda alias Chode Gowda and Chode Gowda alias Kenche Gowda, husband of defendant number 1, have managed to obtain khata on inheritance in their names. And basing on the said legal entries, they've executed a registered sale deed dated 11/2/2023 in favor of defendant number 5 in respect of suit scheduled property. Basing on these elements, they've sought the relief of declaration and injunction. To that, the written statement has been filed by the defendants. It is a case of the defendants that the plaintiffs have nothing to do with the property. And they are the daughters of Chude Gowda, and they have inherited the property. In fact, when there was an interference, they have filed a suit and they have been fighting the litigation from several years. It is stated that the great grandfather of the defendant 1 and 2 is Chude Gowda. He had purchased the suit scheduled property on 27/3/1936. After purchase, got the khata mutated in his name and died. Bhadragiri is the sole son of Chude Gowda, and he had a wife by name Kempamma. They had a son and 3 daughters. Chude Gowda alias Kenche Gowda is only son of Bhadragiri and Kampenna. Second daughter is Parvathamma, Third daughter is Mayama. Fourth daughter is Shurama. They're all, they are no more. And Chota Gowda had 3 children. And after the death of Chota Gowda, the children of Chota Gowda, that is defendants 1 and 2, are in possession and enjoyment of the property. The plaintiff had filed this suit with all false and frivolous allegations. It is their case that the RTC extracts now stand in their name. And they have also filed OS number 84 of 2004.
It was filed by the other person.
Hmm?
84 of 2004 is by Punya Gowda against our father.
When OS number 84 of 2004 is filed by one Pune Gowda, son of Bale Gowda, in that the father of the defendants appeared through advocate and filed the written statements. In respect to the suit scheduled property, Pune Gowda had filed suit for declaration injunction, that is OS number 240 of 2014, on the file of the principal civil judge Kanakapura against the defendants 1 and 2. And they filed the written statement and marked the documents. Then the plaintiff had filed an application order 7 to 10 of CPC and took back the plaint to file the same in proper court. Till date, without representing the plaint against the defendants 1 and 2, has filed the present suit through the present plaintiffs, and as such, the suit is liable to be dismissed. It is a case of the defendants that they are in occupation of the property, and they have executed a sale deed on 11/12/2023 and have delivered the possession to defendant number 5, and from there on, he has been in possession and enjoyment of the property. The next paragraph. The plaintiff had filed an IA restraining the seeking an injunction, restraining the defendants from alienating the property. The trial court had allowed the said IA, and while allowing the said IA, the court had observed that the plaintiffs have relied upon the sale deed dated 31/1936, said to have been executed in favor of their grandfather. Defendant number 5 has relied upon the sale deed dated 27/3/1936 to claim that great-grandfather of the defendant number 1 and 2 by name, Chude Gowda, purchased the suit scheduled property. The court observes that on perusal of the records, it's clear that defendant number 5 has not produced the sale deed dated 27/3/1936. They have produced the certified copy of the sale deed dated 15/5/1936 pertaining to survey number 89/1, whereas the suit scheduled property is bearing survey number 39, and the same is mentioned in the sale deed dated 31/1936. The court also observes that the defendants have disputed the family genealogy pleaded by the plaintiffs and contended that Bhadragiri, alias Bhadragiri Gowda, is not their grandfather. The court comes to the conclusion that all these issues are tribal issues involved in the suit. As such, it is to be held that the plaintiffs have made out a prima facie case for trial, and accordingly, and also a tribal case. But the defendant number 5 has purchased the property from defendant number 1 and 2. If he succeeds in alienating the property during the pendency of the suit, definitely plaintiffs will be put to hardship and inconvenience. And third-party rights will be third-party rights will be created. And it will lead to multiplicity of proceedings. In order to avoid such complications, it's just necessary to grant the relief of temporary injunction as prayed for. And the court felt that the balance of convenience lies in favor of the plaintiff. And if the injunction is not granted, they'll be put to hardship. Aggrieved thereby, the defendants are before this court. Learned counsel appearing for the defendant submits that the plaintiffs are strangers and they are not the grandchildren of Bhadragiri Gowda, as stated by them. It is submitted that they've been fighting the litigation from the last 20 years. And finally, the RTC extracts were changed in the year 2020, and they have sold the property. The plaintiffs were never in possession of the property. The earlier suits and the litigation which they fought, at the instance of that person, all these suits are filed in the name of these plaintiffs. He submits that when they are not in possession of the property and from the long time they're not bothered about what is happening to the scheduled property, they're not entitled for injunction. In that regard, he had relied on a judgment of the apex court in Mandali Ranganna and others versus T. Ramachandra and others, reported in 2008-11 SCC 1, where he has relied on para number 22 of the said, or the 22 of the said judgment, extract para 22. No, 21 and 22. He has relied on 21 and 22. Basing on this, the learned counsel submits that the court has, while granting injunction, courts have to take into consideration all these aspects which the trial court had not taken into consideration, and the plaintiff is not entitled for injunction. Then he has drawn the attention of the court to the application that is filed seeking injunction. It is a contention of the counsel that there is no verifying affidavit. In that regard, he had relied on another judgment of the apex court in case of the constitutional bench of the apex court, reported in case of KK Nambiar versus Union of India, reported in AR 1970, Supreme Court 652. He relied on para number 11, extracted. Basing on this, it is submitted that the defendants, the plaintiff is not entitled for injunction, and the trial court, without considering all these aspects, has granted injunction and the same needs to be vacated. Next one. Anything else?
That's
The next part, learned counsel appearing for the plaintiff, the submits that the defendant, there is no relationship between the defendant and the plaintiff. Learned counsel, drawing the attention of the court to the finding of the trial court, submits that the property that their source of title to the plaintiff is a sale deed dated 31/1936, and as per the written statement, the source of title to the defendant is 27/3/1936. The trial court had observed that even that document is not placed before the court. In fact, they have placed a document, a sale deed dated 15/5/1936, which has nothing to do with nothing to do with the sue schedule properties, as it pertains to survey number 89/1, whereas sue schedule property is survey number 39. It is submitted that taking advantage of the name, the similarity in the names, these kind of
survey
applications.
number 79, my lord.
79, new number 79/6.
79.
Yes, yes.
That's what I said.
79.
79. It is submitted that taking advantage of the similarities in the name, the defendant is coming up with such a plea it is stated that till 2020, the property, even as per the RTC extracts, it stands in the name of the plaintiffs, the first plaintiff's father-in-law and other plaintiffs' grandfather. Once they came to know about the change of RTC extracts and the alienation made by the defendant, they have filed a suit just because the defendant is fighting some litigation, which is some litigation, and where they are not the parties, it is not necessary that, and basing on that, the defendant is not entitled for any, he cannot have any advantage of the same. He submits that the trial court, by way of a well-reasoned order, had granted injunction, and there are no grounds to interfere with the well-considered order passed by the trial court. Next, having heard the counsels on either side, produce the material on record. The suit is filed for declaration and injunction. According to the defendants, their great-grandfather had purchased the property on 31/1936, and they have succeeded to the property, and they have been in possession of the property till 2020. Till 2020, RTC extract stands in the name of the grandfather of the plaintiff. The defendant also, according to the defendant, the property, their great grandfather had purchased the property by way of a sale deed dated 27/3/1936. Admittedly, the said document is not placed before the court. What is placed as a sale deed dated 15/5/1936, which is not pertaining to this property, the sue scheduled property. Now, both of them, though the documents are not one and the same, but both of them are referring to their source of title to Bhadragiri, or the property purchased by his father Chude Gowda. The court had rightly, at paragraph number 11 of the order, had observed that all these issues have to be decided by way during the course of trial. At this stage, the court cannot go into those aspects. Once the court cannot decide the issues at this point of time, the court has to look at a prima facie case. The document that is filed by the plaintiff dated 31/1936 and 36, which shows the source of title to the plaintiff, and particularly considering the document that is placed by the defendant, the court has felt that the plaintiff had made out a prima facie case. Already, after the RTC extracts have changed in their name in the year 20, defendant had sold the property in favor of defendant number 1 and 2 have sold the property in favor of defendant number 5. Court rightly observed that if there are further sales, unnecessarily it gives rise to multiplicity of proceedings. The judgment which the petitioner is relying on, the appellant defendant is relying on with regard to grant of injunction, in the considered opinion of this court, that do not apply to the facts and the circumstances of this case. Then coming to the next issue of verification, affidavit and all. None of these issues were never raised before the trial court. This court, exercising the jurisdiction under Article 227 of the Constitution of India, is not inclined to go into those aspects. In that view of the matter, this court finds no reasons to interfere. Accordingly, appeal is dismissed.
Trial court may be directed to dispose of the suit earlier.
23 suit, it can't.
Please, my lord, but anyway,
We can't give such directions to the trial court when they have other pending matters.
Cell number 2. Then spread. Ritesh, petitioner.
Yes.
Did you look?
Appeal for the petition in this case, ma'am. So this is the matter arising out of the order at Annexure A, my lord. The petitioner has filed an JNWC, my lord, in that he has filed an interim application, my lord, for custody of the children, which is the application is Annexure H, page number 75, my lord.
Page number?
H, page number 75, my lord. My lord, in that he says that, my lord, for the custody of for the interim visit of the children's, my lord.
What happened to this?
My lord, the lower court has been considered the application partially, my lord, by granting and my lord, the operative portion of the order is at page number 34, my lord. The order is that, my lord, petitioner is permitted to, at page number 34, my lord, permitted to meet the children on first Saturday of every month between 4 to 5 p.m. at Mediation Center, Chitradurga, my lord. But my prayer was that, my lord, on every Saturday, Sunday and government holidays, I would take both the children to
What is the reason given by the court for granting such a relief? Let's read the order.
My lord, there is no any such reason, my lord. Only the reason given is that, my lord, the children know they are
Where
residing
the children are staying?
with their mother in Chitradurga, my lord.
Where do you stay?
In Bangalore, my lord. My lord, I have filed an MC case, my lord, before the family court, my lord, and also JNWC, my lord. Both the cases has been transferred to Chitradurga, my lord, which has been,
Notice to the respondent, then we'll pass orders.
my lord, in spite of this, my lord, even obeying the order of this lower court, my lord.
Understand.
Please.
He has to come before the
No,
court.
even on Saturdays, I am not being permitted to see my children. From 40 months, I have not.
That is not the cause of action. What is this?
Because
Ask them to install that. It is unnecessarily creating nuisance. Ask them to come. Now, no ex parte orders will be passed in GNWC matters.
Please, my lord.
You have to take notice. If you can take notice before 30th, we'll give some date.
Please, my lord.
Yes.
My lord, the another humble submission is that, my lord, even the order of the court has been not yet
If it is
complied,
not
my lord.
complied with, you have a remedy. That's not by filing a writ petition.
Because, my lord, my father and mothers are 71 plus years, my lord.
I understand, for all that, if the respondent is before the court will pass some orders. No ex parte order. That order, the court, or according to you, the order passed by the trial court is not, she is not complying with.
Please, my lord.
This order also she will not comply. So let her come before the court, then
Even
we'll
on
ask
the
her.
regular notice may be issued, my lord.
Yes.
Lord,
Notice
any
to
date may
respond.
fix my short test date, my lord.
Hand summons?
Lord, because I don't know what is the relationship between the
Then,
petitioner and respondent, my lord.
Pose this matter, because then.
Even before the lower court, the council and the respondents not regularly, they're not appearing.
No, anyhow, if the registry has to issue, send notices, it will not be possible before vacation. It will have after vacation.
Immediately after
Notice
vacation.
the response.
My lord, immediately at reopen.
On 15th October.
Grateful, my lord.
Yes, next. Yeah. Where is the memo? Call them and ask them to install this board here.
I appeal for the petition. Enhancement of maintenance. Serial number 3. Serial number 3.
Memo is fine.
Notice, I don't know whether respondent is not represented.
Hello, madam, your case is not yet called out.
It's
Dictation
not
is
recorded.
going on in
And,
previous
the
matter.
council is permitted to retire. Already another council has filed wakalat in this case. Yes, delete the name of, what is his name? So,
this-
D'Souza, that to be deleted.
This is the matter of itself. It has been entrusted to us, my lord. Earlier council name was shown in the cost.
That's why it has been.
Please, please.
Till number 3, till number 3.
I appeal for the petition, madam.
Yes.
Respondent is, I don't know whether it's, notice is served. I asked for enhancement of maintenance, madam. He has not paid the maintenance.
Notice is ordered.
Yes, madam. I served also.
Then council the petition is permitted to take out notice. Where is the
No, he
memo?
has served, madam. They served on the advocate. I filed the acknowledgement also.
What is the name of the advocate?
Advocate. 1 minute. What's the name of the advocate? Hello, we serve the advocate for serving for filed wakalat in the family court. Anyway, madam, we'll take notice again.
Hand summons. Petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. We shall file a memo to that effect. Pose this matter when?
Next week, madam.
Pose this matter on 27th.
Right.
Yes, next.
Cell number 4. Chandrakant Gaule. For petitioner.
Yes.
Dinesh BN.
Respondent.
I appear for petitioner, my lords. The respondent herein is wife who filed a matrimonial case for divorce, my lords. Meanwhile, she made an application for the interim maintenance under section 24 of the.
That's more comfortable than this. It's going. And it is causing unnecessary inconvenience. Let's have the same box here. Why you have removed that? Actually, this is giving more inconvenience. It's echoing, and all of a sudden, if you have to keep it like this, it's difficult for the court. But it should be the same. So you're experimenting on this court. Keep it this side, then we'll see. We'll see if it doesn't work out, then we'll. Yes. What is the impugned order?
The impugned order is that the honorable court directed us to pay 25,000 rupees of the maintenance to the respondent herein, my lords. So we have challenged the said order. The order was passed on 24/3/23, and we have filed a writ petition 27/5/24. My lords, on the last date of hearing the matter, and directed us to file a order sheet so that we said that since the mediation proceedings were going on, we were not able to come before this honorable court. So my lords wants to know on what particular day
When was the order passed?
passed on 24/3/23.
24/3/23. That's questioned in 2024.
Please. So we said that since the mediation proceedings were going on, we concentrated we are settling out the matter. So we were not able to come before this honorable court. My lords want to know on which date the mediation proceedings were going on. So we filed a memo of the order sheet on 11/9/24. My lords, kindly come to page number 16. That is the case status.
Page number?
16.
Yes.
My lords, from 27/11/21.
27?
11/21. To 29/7/22.
Minute, I'm not able to find that date. Where is it? You said page number?
16. 16 last but second line. Second.
20?
7 level 21. To 29/7/22. The mediation proceedings were going on.
No,
Even
you're talking about an order of 24/3/2023.
please, my lords, kindly, that is, my lords will find it in page number 17.
Yes.
My lords, even after that, my lords, kindly see 24/23.
No, please refer to something what is happening after this order, 24/3/2023 order.
After this order, my lords, kindly 13/6/23 to 13/7/31/7/23, the conciliation, my lord.
No. Please come to this 24/3/2023, 18, please.
Orders on IA. The orders were passed to.
Objection.
Then
Petitioner's
conciliation.
evidence, petitioner's evidence. You are
My lords,
reading
no.
evidence.
On 31/7/23,
On
objection.
that day, objection for that conciliation.
Objection bar conciliation. My lords, the set.
After that, on 31/7, petitioner's evidence. 31/8/2023 petitioner's evidence, 9/10/2023 petitioner's evidence. And you are continuing with it.
My lords, please, and
Execution has also.
my lords,
Huh?
my lords,
Execution, we have
still,
filed execution also.
Yes.
My lords, still 31/7/23, the mediation proceedings were going on. My lords, I have a judgment to say that where for the filing a writ petition, there is no time limitation. May I pass the same, my lords? My lords, may I read this, may I read? My
Please
lord-
read. There is no limitation, doesn't mean that you will file the writ petition
My
after
lords,
10 years.
approximately, there is a 10,
Reasonableness.
my lords, reasonableness, there is a 10 months
I'm
delay.
not finding any reasonableness from this
My
proceeding.
lords, no, objection bar conciliation. My lords, mediation was going on until 31/7/23. There is hardly a 10 months delay, my lords.
Hardly.
10 months delay, my lords. I'm sorry for that, but my lords, there is a 10 months delay.
But
My
I
lords,
remember, whenever you want to, you cannot come before the
my
court.
lords, no, my lords, kindly see. My lords, what happened is, my lords, after that, I'm paying, then I found difficult to pay the
First,
maintenance,
court
my
has to
lords.
pass one order, then they have to file execution, then you will come before this court.
No, my lords, I'm paying the maintenance. I'm paying the
Then
maintenance,
don't,
my
why are
lords.
you bothered about the
My lords,
execution?
now I'm facing very difficult to pay the same, my lords. My lords, really, I'm facing a, so I'm before the court. And meanwhile, the time was not granted me to file assets and liabilities without
That you should have asked long back. If the moment the order is passed, if the assessor liability, your opportunity is not given, then you should come before the court and question it. You will not realize it after a year from the date of order. When is this petition filed? What is the date of this petition?
on 27,
5.
on 27/5/24.
After 14 months.
My lords, hardly 10 months because from 31/7/23 till that time, the mediation proceedings were going on and the settlement talks between the parties were going on. So I was concentrating on that.
That I have seen, the date I have seen.
My lords, there is 10 months delay. I request my lords to kindly condone the delay because
No, you
even
said, no, there is no question of condoning the delay because you have a right to file this writ petition whenever you
my
want.
lords, I'm sorry. Of course, my lords, it depends on the facts and circumstances of the each case while filing the writ petition, my lords. And meanwhile, my lords, the Honorable Trial Court does not only look into my assets and liabilities, even they didn't peruse the
What
documents.
is the present status? Are they paying?
No,
We are paying, my lords.
No, my lord, they have paid last on 26/24. From 20 June 24, they have paid 25,000. As on date, 10,63,000 is pending.
No,
10
my
lakh.
lords, we are regularly paying. That's what the instruction.
File a calculation memo will
Unless and until
not. These kind of, the forum shopping, you can't do like this.
my lords, because
The
kindly, my lords, kindly come
Petitioner
to.
with the next date of hearing shall file before this court.
My lords,
The
we will file.
amounts that are paid so far to the wife. And basing on that, further orders will be passed. When will you file?
My lords, on 30th.
30th. You're taking a chance, sir. 30th, yes, 30th.
My lords, I want to bring my lord attention to page number 38 of my writ petition.
Understand, even if you're the other side also, the same order will be passed. Please understand. You can't.
My lords,
you
the
can't
trial
submit
court
it.
even did not look into the
Did you not question
documents.
it?
Documents.
That's all about the conduct of your party. Let him come out. What is that he's paying? What is the respect he has to the orders of the court? It is not that one order is passed by the court. Conveniently, you'll go to the appellate court and set it as to set aside after some time when it is after 1 year. It won't happen like that. Please.
My lords, we are not requesting my lords to set aside the order. We are only requesting to decide the quantum of amount.
Because you pay, then we'll decide.
10 lakhs.
My lords,
That's why please don't go into all that. Come up with what you have paid, then we will decide.
Please.
Yes. On 30th, but she wants it on 30th. Yes.
File. Ravines, petitioner, Rashmi George. The respondent.
Appearing for respondent in this case, my lords.
The petitioner in this case.
What is that? Yes. Yes.
My lordship, while this writ calling in question the order that was passed in GNWC, the court below, my lordship. The impugned order. The impugned order was
passed in the favor of the respondent to entitle a weekend custody, my lordship.
Let's see, where is the order?
Lordship, page number 66, my lordship, of the writ
Page
petition.
number?
66.
Yes.
Yes, my lord. My lordship, the respondent father was entitled to a weekend custody of the child, my lordship, on second and
What
fourth
is the age
Saturday.
of the child?
6 years, my lordship.
You are aggrieved by that.
My lordship.
You are aggrieved by that.
Yes, my lordship. The
Ah.
thing is, from the day the order was passed on 25/4/2024, my lordship, and from then on, 4 visitations has been done, my lordship. The petitioner in the present writ petition, the mother, on 27 July, 10th August, 24th August, and 7th
27?
27 July
Mm,
and 10th August,
mm,
24th August,
mm,
and 7th September, my lord.
mm.
My lords, on all 4 days, the visitation was, we are complied with the orders, my lords. My lords, the only thing that needs to be submitted before the court, my lordship, during the visitation, my lords, the father who is the respondent, my lords. My lords, the respondent, during the visitation, he leaves the child in the ground of the sports arena and he starts, I have submitted the memo of photograph, my lords, where the respondent father leaving the child is using his phone and is sitting far away from the minor child without interacting with him, my lords. The memo of photographs have been served and it's been submitted to the court, my lords.
So you want, what you want the
No,
court
my
to
lordship,
do?
just the thing. And on one other such occasion, my lordship, the respondent father has left the minor son 2 hours without attending, my lords. He was skating there in the arena, and without attending, he has gone out on work on some personal thing. My lordship, the minor son has come, informed everything before the petitioner, my lords. During the visitation, after the visitation has been done, he used to come back to the home and he used to share all the things with the petitioner, my lords. During the custody also, he has shared few photographs, my lords. If that can be seen.
Where is the photograph?
My lordship, it's submitted through a memo, my lords.
What is the first photograph?
Photograph of the child, minus.
2. Page number 2.
Yes, my lords. The photograph.
What do you want to tell the court by this?
No, my lords. He's in the custody of the father, my lords. That is the respondent's house. He's in the respondent's house. These are the
The person
photos
who
that
is
was.
seen there is the father. In the photo, page number 2.
He is present. Father is present.
The one who's sitting and using his phone is the father, my lords.
And
then is the photograph of the washroom, my lords.
Huh?
The photograph of the washroom, the untidiness. The minor son has sent it to the mother, my lords. That is the thing, my.
What's
it, my lords.
happening?
Milords, I have to make my proper submissions in front of the court.
1 minute.
So this is the thing, my lords. The only.
No, there's so much of merit
Page
on
number
the
3,
order.
what is that?
My lords, one, the way the respondent is using his phone, my lords.
3. You have the numbers, I think. You have given numbers. Some lady is seen in this photo.
Minor son, my lords.
A minor son and also a lady are there in page number 3. Please photograph, Mr. Counsel.
No, Lords, that is a photograph filed by us, filed by the respondent. We had on 18/9, we are filing few photographs in this honorable court to prove that the child is happy with the father.
Where are your
After-
photos?
And thereafter,
Yes, we have
yesterday,
some.
day before, they are filing another set.
If I another set yesterday, madam.
Immediately after that, they are filing another set on 19 to disprove that the child is not happy.
These are the photos filed by you.
Yes, my
That-
lords, which was filed yesterday.
In first photo, the boy is seen
The boy
on
is
the
seen,
playground.
and down, it is the respondent sitting on the bench, my lords.
Then
My lords, and then using his phone, the respondent, and then the photograph of the thing that was shared by the minor child to the petitioner, my lords.
must be the mother is asking for all this.
No, my lords, it's just
Land council appearing for the mother submits that as per the photographs filed by them before this court, whenever the father is exercising the having the interim custody, he's not taking care of the boy. He is leaving the boy to play for himself and sitting somewhere, and there is no communication according to them, according to the mother. The proper hygiene is not maintained in the house, and photographs of the washroom also filed. It is also submitted that the father is talking about the disputes between the parties, which are not in the interest of the minor. It is the case with the father that mother that the minor is not comfortable spending time with the father, and if the court interacts with photographs stating that the child is having good time with the child is the boy is having good time with the father, and the mother is instructing him to take the photos, and all the time the boy is on phone. It is submitted that even before the trial court also, in the interaction court has observed that the mother, the boy is tutored by the mother. It is submitted that the father is taking care of the child, and the photographs are also filed to show the same. Next para. Having got the counsels on either side, peruse the material on record. The boy is aged 60 years, and the boy is given with a phone, and he is going to the father's place and taking the photographs and sending the mother, and the mother is placing those photographs before this court. And the father will also file some photographs to show that he has been taking care of the child well, and some more allegations are made. In all these visitation matters, whenever one of the spouse is given visitation, the parties are more in collecting the evidence to show before the court that how the boy is not comfortable. In the heights of this cases, a boy of 6 years is given a phone so that he'll take the photographs and he'll send it to the mother. None of all the submissions that are made on behalf of the petitioner are not the reasons for this court to pass any other order or take a contrary view what is taken by the trial court. This is a writ petition filed by the mother. This court is not inclined to go in any of the allegations that are stated by the father. And the mother shall not come up with these kind of frivolous petitions without any basis. Accordingly dismissed.
Cell number 6. Much obliged. AM.
Yes.
Lord, the respondent has filed a custody petition. Minor against the minor children. The minor children, my lord, file an application seeking maintenance. They are under the custody of their maternal grandparents. The mother has died long back, my lord, by committing suicide in the year 2011. Since then, my lord, they are continuously into the custody of their maternal grandparents. They are providing them education and maintaining them. My lord, this petition now in the 2021, my lord, this custody petition is filed. My lord, I seek for
Petition is filed by the father.
by the father.
And when the mother died?
2011.
From 2011 till 2021?
Yes.
They are with the grandparents.
Even now, even till now. Even till now, they are, in fact, my lord, in between there was a.
What is the age of the children now?
My lord, the girl child is aged 16 years.
Oh.
My lord, the male child is aged 15 years.
Then what happened?
My lord, the application has been rejected on the sole ground that this is a custody petition and this is not under the Hindu Marriage Act. And no, there is no enabling provision to provide maintenance here in the petition. And my lord, may I place reliance upon a Bombay High Court judgment? Similar situation, my lord. The Bombay High Court held that inherent powers can be invoked in a custody petition under the Guardian and Wards Act, and there is no provision to award maintenance.
Yes.
My lord, may I take my lords to paragraph 13 of the
Under section 12(1) of the said act, the court is empowered to make an interlocutory order
yes,
as to protect the person or property of the minor as it thinks fit.
paragraph 14 is more on the point, my lord. It is to be noted that the present proceeding under section 7 of the act being entertained by the family court under section 7(1)(a) of the Family Courts Act.
Take out notice.
Please. May I serve the counsel also? May I serve the counsel who appear this?
The petition is permitted to take out notice on the counsel, okay, take out hand summons on the counsel appearing for the respondent for the trial court and file a memo to that effect. When do you want?
Any date, my lord.
It's all about when can you serve?
My lord, I can serve within a week.
Pose this matter on 1st October. Yes, next.
Till number 7.
I appeal for the petitioner.
Yes. Yes.
Already.
Before my lord, in special circumstances wherein the wife who is living in a jointly held flat, of which I have no objection for her to exclusively live there. And there is the divorce petition pending, which is filed by the wife. And the pending the disposal of the case, or some talks did take place for the purpose of arriving at an amicable settlement in the dissolution. The parties now they are not in good terms, and the marriage has to go is the approach of both the parties. Now, in those circumstances, what happened was, as my lord will see, as per the cast title in the MC petition, which my lord gets it at page number 21, it is filed by the wife, who is the respondent herein, 7704 of 2023. Kindly see the residential address, which is Mayflower Brigade Millennium, JP Nagar 7th phase, Bangalore 78. This is the place where she's living even as on today. Due to the marital discord, the husband moved out of that house, and thereby all the usual things happened. 498A, and then the other cases which the couple are fighting it out between them. Now, in the meanwhile, what happened was there was a jointly booked flat, which is in Prestige apartment, which is described in the petition, which my lord gets it at page number 10, which is the Prestige apartment. There were delays in obtaining the possession and the registration. Good sense did prevail between them to go ahead with the purchase of the property. Thank God.
Yes.
Now, the only thing which happened thereafter is that the petitioner is saying the petitioner moved into that flat. Now, now we are not questioning the ownership of the respondent. She is the joint owner of the flat, of the second flat also. I don't dispute her interest in respect to the property. The only approach which I took and tried to convince the respondent is that have a live and let live policy. Let this flat is jointly owned by us.
So what is the order and what is the?
No, that is where the difficulty lies. We filed an application under at page number 39. My lord, there is no order as of now passed by the trial court. Now the difficulty is that I will explain that. At page number 39, I filed a IA.
Yes.
Seeking that she be temporarily restrained from interfering with the peaceful occupation. I didn't even say peaceful possession. Now I am in the flat. Now she writes an email, which will be very interesting. Or even though I dispute the way the email.
Now, MC,
yes,
husband sought a relief of injunction.
Yes, madam.
In MC,
yes, madam.
Husband has sought for a relief of injunction.
Yes, yes, madam. We filed an application, and now what, unfortunately, the trial court adjourned the matter by a short date and thereafter to a long date, which is at page number. Where is the page number of this? Order sheet, which my lord gets it in the end. You not page number? 47. PO is on training, call on 19/10/2024. Our difficulty is that, my lord, having bought a second flat, and the first flat is jointly purchased. Second flat is also jointly purchased.
No. What is the scope of the litigation and what is this
The
order?
scope of the litigation is the divorce petition filed by the respondent. It's not my.
So in that case, the court will only decide about the matrimonial, whatever that is
And
called,
also
whatever it
alimony,
is,
alimony.
and also alimony.
Yes,
And why should the court grant these kind of an order in an MC?
my lord, it is a dispute arising between the parties and as if shared householding.
No. If it is, that is under the Domestic Violence Act and other things, the wife will ask.
Yes.
No, now the husband, if there is any dispute with regard to the property, he can file a suit with regard to the same. How can it be decided in an MC?
No, in order to avoid multiplicity of proceedings, and it is not alien dispute beyond the marital
But there is
relationship.
no relief in MC. What you have sought as a dissolution of your marriage.
Yes, but which she has sought. Not I have not sought. She has sought. I am the respondent there.
So instead of relegating the parties to other, it would be, there will be in the same
Yes,
court, in a family court, the
yes,
suit proceedings will be heard.
Yes, madam. Yes, madam.
Not in a MC seeking an injunction of this nature. How is it? How is
Not
it like
otherwise, I mean, kindly, while I would say that I bow down to the proposition which the Honorable Court is, but now in the instant, I have said it, in order to avoid multiplicity of proceedings, there is no dispute with regard to the ownership of it. I only sought a restraint order, more so, in fact, trial court did express the view that there cannot be an injunction against a co-owner. Against a co-owner. That was the proposition which was projected against me. Now I am confident that, my lord, this honorable court will take a total view of the circumstances, not that in compartment. At least my experience before this honorable court is that this honorable court is known for taking.
Unfortunately, in this case, the court has a different view.
No, that is I have a job. I have a work on hand to convince the honorable court. Kindly look at the circumstances. The harassed husband.
No. This is a completely enlarging the scope of the matrimonial proceedings. The purpose of dealing with all the issues between, even if there are some property issues and other things, in a divorce petition, court will not deal with all that.
It does for the reason that, my lord, it does for the simple reason that to put if this were to go in for a compromise, if at all they were to go in, now in the present case, we reached an advanced stage of compromise. But it did break down for the simple reason that the respondent came with a very unrealistic proposal, 2 crores alimony and the visitation right. And I, as an officer of the court, I have a reasonable amount of conviction that the matter may get resolved. But while resolving, and we are only seeking for a level playing
At
field.
best, the order that can be passed in this is the early disposal of this petition and nothing else.
Early disposal of the application, IA, my
That
lord.
is pending.
Yes, ma'am. I leave it to my lord on that. But the only thing kindly appreciate is some breather can come to the husband, because he is living in such a state of affairs that he has to live in his own flat under the threat of what I would say that from the wife is living comfortably in a shared householding, which I am not disturbing. This is a new flat acquired during the pendency of when the proceedings are there. I am only suggesting that please let the husband be allowed to live in peace. He is not living in peace because of the matrimonial and acrimonial.
We understand the difficulties, but there is a procedure for everything. We cannot just like that enlarge the scope of these petitions. Already their scope is enlarged.
Yes, ma'am.
So we can't further enlarge the scope for all this.
I leave it to my lord. If there is some amount of coming to the rescue of this harassed husband, kindly exercise.
We'll come to the rescue of harassed husband in an inappropriate application, not in this. Please come.
I leave it to me. Till the disposal, would my lord consider status quo, my lord? I am till the disposal of the application by the lord.
If it is, I have my own doubts on this maintainability of the application. In that, there can't be any intermodal. The present petition is filed. Seeking the following reliefs. It is stated that the respondent herein, who is a wife, had filed an MC seeking divorce. The husband is in occupation of the jointly purchased owned property. And the wife is residing in a property which belongs to both of them. Due to constant torture and harassment by the respondent, the respondent wife, the husband is forced to move out on 8/2/2023 and is currently residing in a rented flat at B1102 Queen's Gate, House of Hiranandani, Pegur Village, Bangalore. Earlier, there was a proposal for earlier in the mediation. She has come up with a proposal which could not be fructified. And the wife is making unreasonable demands. The husband on 8/8/2024 has moved into a scheduled property along with his residential belongings. However, on 10/8/2024, the wife visited the property with her son and a dog with the intention of creating an acrimonious situation. There was exchange of words wherein the petitioner requested the respondent to keep away from the property pending division of the properties. The respondent used abusive language and threats have caused significant distress to the petitioner and to the husband and his elderly parents. The wife, being in occupation of a jointly owned flat, is unjustifiably interfering with the husband's peaceful occupation of the property. The wife has also made false accusations against the husband and his parents through emails dated 10/8/2024 and 11/8/2024. As such, they have filed an IA before the court seeking injunction. And the same was not entertained. The same was adjourned by the court and a long date is given. That is on
19/10/2024.
19/10/2024. It is submitted that unless an order of status quo is granted by this court, the petitioner husband would be put to a lot of inconvenience. Until pending consideration of the application, there shall be an order of status quo. This court is not inclined to grant any relief in this petition, nor this court is is not expressing any views on the application that is filed. Considering the submission of the senior counsel appearing for the petitioner, the trial court shall decide that application by the as expeditiously as possible. It shall dispose of the application within 1 month from the date of receipt of the copy of the order.
My lord, may keep it as 1 month from today because the other side is
1 month
advancing.
from 1 month.
The other
And
side is advancing the case.
And this court is not proposing to issue notice to the respondents, as early disposal is in the interest of both the parties.
All contentions left open.
That's why I said I'm not.
No, the difficulty is on that, my lord, specifically rejecting my prayer of that status quo may be modified to say that my lord is not granting and I have not taken the order. But my lord may not say that the honorable court is, the court is not in that. I'm sorry, I'm pointing out only that it may carry an impression that I have not been able to
No, at the
convince.
same time, why a court has said is let the trial court not understand it that the court is of the view that such an application is maintainable. For
No,
that, the
no,
court
no,
has
not at all. No, if my lord were to say it is rejected, our answer there will be, it will be difficult for me. My lord may just, I'll try to I'll make an attempt to convince the
Yes,
trial
yes,
court.
yes.
I'm greatly
While
obliged.
correcting the order.
Yes.
Yes. Next.
Number 8. Esteemed Muniswamy Gowda,
Yes.
Sarika,
The 3 years child, overnight custody has been granted. As against that, the mother has filed this petition. Earlier, My lord, the father also had not asked for overnight custody. My lord, the application he
So
has asked
how
only.
long the day visitation is going on?
My lord, your lordship has granted
Uh.
in the writ petition in the year on June 2024. That writ petition order is at page number 59.
Where is the order impugned now?
My lord, the order impugned. And it's page number. It starts from page number 21, my lord. The particular relevant portion is at page number 25. Or 24, it
This
starts.
arrangement, no, when they were separated, when from when they are saying separate?
My lord, when the child was 1.5 years, he has took away the child. And thereafter, my lord, I filed a habeas corpus. That order also produced before this court. And thereafter, the custody was given to me.
No, what is the reason given by the court?
My lord, the court said, my lord, because the father asked for every day in the evening to see the child. It's not possible, and as such, I'm granting Saturday and Sunday twice in a month. It's at page number.
Where is that observation?
My lord, the relevant portion is at page number 24, my lord.
The respondent is IAS.
In his
not
IAS
the-
sought for grant visitation rights, allowing him to visit his son in the evening and every day. In this case, it is undisputed that on 2/9/2018, the marriage of the petitioner and the respondent was solemnized at Baswangudi, Bangalore. And thereafter, the petitioner, the wife started leading her marital life with the respondent at his abode. The materials on record make out in the month of August 2021, when petitioner was living with the respondent, she gave birth to their child. And thereafter, both the petitioner and respondent with their son lived in the same house till 22/2/2023. So both the petitioner and the respondent along with their child have lived together till their child attained the age of nearly 2 years. The materials on record clearly make out that the residents of both the petitioner and the respondent are here in Bangalore, and the residences in between them are not far away from each other. The materials on record make out that.
The order is already acted upon?
Yes, madam.
No. This order.
No, madam. No, madam. The materials on record make out that the respondent has completely his MTech and the petitioner has completed BCom. Now the child may be about 3 years old. The respondent in his IA has sought to grant the visitation rights of the child in the evening every day, which is impracticable. The materials on record make out that both father and mother of the respondent are living with him. Similarly, the distance between the residence of the petitioner and the respondent is about 900 meters. In the backdrop of these facts, I am of the opinion that it is inconvenient, both the petitioner and the respondent, keeping the child allowing visitation rights every day. Since the child all along has been grown along with the father and the respondent, the father is living with the parents, particularly his mother in the interim custody of the child is given for about 2 days, twice in a month.
No, they're staying near to the other, it's just 900 meters apart.
Malad, it's not the question of.
At least, no, let him have, till the notice is served on them. We'll modify the order. Let him be there from, let the boy be taken at 10 o'clock and evening again, he'll get him back.
Malad, Lordship may.
Not the overnight custody.
Because when the visitation rights was granted to him, my lord, there are some things, certain foods are not to be given to the child. That has been advised. In spite of it, my lord, in spite of warned by the wife to the husband.
I remember this case.
Yes, my lord.
Initially, if I remember in this case, an ad interim order is given.
Yes, my lord.
Later, the husband had entered appearance. Thereafter, this order is passed. I remember that.
Yes, madam. Now the photographs also are produced because the child was taken to the hospital because the child doesn't know what to eat and all, madam. The father being a responsible person, at least he should know that what should be.
We tell them to do it.
Yes, my lord, but not that,
Even when both of them are together, there's all these kind of things
my
tend to
lord,
happen.
not for
So
the,
let's not make them out of proportion, let it not be blown out of proportion.
my lord, not for the morning from 9 to 10, 5 or whatever, but at least let it be for 3-4 hours, let him take, my lord. After that, we'll see.
Trial court had granted an order whereby the owner to continuous
Yes,
2
sir.
days is given. So you can't bargain for such a short time. It should be from 10 o'clock to 6 o'clock in the evening. So the overnight, let the father, let the boy will come. This arrangement as made by the court, first what we do is, let this Saturday and Sunday, let the father have that kind of an visitation. We'll post it on some other day. You can tell the court, by the time you take out notice on them also.
Well, I already caveat, I have already served on him.
Oh, who is
Caveat, he has
appearing?
entered caveat.
Govind, Shrikar A. Jai
Then
Govind.
please inform him. We'll take it up so that we'll pass an order before in his presence.
Yes.
Password.
Chair number 9. Satish TV, for petitioner.
The petition,
Yes.
interim maintenance,
How much is granted?
6,000 plus 8,000.
What is 8,000 is expenses?
8,000 towards a wife,
Hmm.
6,000 to daughter.
6,000 to
Total
daughter.
14,000.
What is your income?
My income is, I am a labor in poultry. So
And what is the finding of the court on that, on your income?
my income quote, I conclude that in page number 10, my lords.
Hmm.
Page number 21. In middle, in the absence of positive material placed on the record,
You're reading at page number?
21 in judgment,
Hmm.
and middle of the operating portion.
Hmm.
In absence of positive material placed on record before the court by the respondent, this court consider opinion that respondent is a developer and doing a contract work. Nothing, no.
No, please come before that. Para number 11, you start reading.
Para number 1, relevant to here note that petition number 2 has submitted her statement of assets and liabilities, stated that respondent is a BCom and LLB graduate, but not completed a LLB. He is just admitted in the LLB and not completed his degree. And graduate and working as a developer and doing a contract business and having 5 acres landed property at Huilalu village, Nagavara Post, Ilvala, and also owns house property. She is unemployed and she is taking shelter in her father house. Respondent has
What you will pay?
That's 3,000 each. For temporary.
Pay 4,000 plus 4,000, 8,000. Please come. When is the
3,000.
petition filed? When is the petition filed?
Petition filed on 21/12/2023.
21?
12/2023.
10 months.
10 months.
80,000. The petitioner husband is agreed with the order of the trial court dated 11th July 2024, whereby the trial court had granted an amount of rupees 8,000 to the wife and 6,000 to the daughter. Total an amount of rupees 14,000 is granted towards their maintenance. Then council submits that is working as a coolie. And it is the case of the wife that that he is doing contract works. And the trial court observes that in the absence of any positive material on record before the court by the respondent, by the husband, that the respondent is a developer and doing contract work. Such finding of the court is contrary to law and facts. He submits that. Being a poultry, what is that?
Poultry labor.
Being a poultry laborer, it's difficult for him to pay an amount of rupees 14,000. Considering the same, there shall be stay of all further proceedings on the condition that he shall continue to pay 4,000 each to wife and the daughter. And the arrears for 10 months, 80,000 shall be paid within a period of 4 weeks from the date of receipt of the copy of the order. Petition is permitted to take out notice on the counsel appearing for the respondent and summons to the counsel appearing for the respondent before the trial court and file a memo to that effect by 14th of October. If the memo is filed, this matter on 21st. Yes.
Cell number 10, Dhananjay Kumar for petitioner, Sudesh Kumar Acharya for respondent.
Appearing for petition.
Yes.
Your Honor, we have already paid the amount which was due.
Yes.
Paid, Miller, received.
My lord.
The only thing is whether interference required.
And
No,
one
for
more
it.
submission.
Totally desert,
They were asked to comply with the order.
yes.
One more submission, my lord.
Yes.
Despite the order of this honorable court that not to precipitate the matter on the last date 13/9 in the trial court, they have issued warrant against the petitioner, my lord. So if your lordship can pass an interim order, that would be great. Or else the petitioner will be facing a lot of difficulty.
No, my love, if she would have produced, my learner friend should have produced the order before the court, my love. I did not produce any orders, my love, because thinking that they would not, because of your lordship's order. They would have produced the copy of the order before the learned judge. He is not presenting before the court, himself before the court, my lord, nor appearing through the counsel there. So it might be, my lord,
Order by this court.
and normally, my lord, the order would be communicated to the court also.
Sorry,
When is the order passed by this court directing you to pay the amounts?
on 23rd, 8,
23rd?
8. 23rd August.
There is an order here. Till then the respondent shall not precipitate the,
Is there, it will be communicated also.
They have issued a warrant against the petitioner, my lord.
what he will do for that? He will not issue warrant.
In the trial court, they are.
Then you have to, that's for you to bring to the notice of the trial court. How
Was
can you
brought,
find
but-
fault with them?
No, my lord. It was brought before the notice of the trial court. Despite that, they have issued a warrant.
Who has issued?
The trial court has it.
Then how do you find fault with them, with the respondent?
If there is a clear order stating that the trial court will not precipitate in the matter, it would be great. Or else they will continue to pass.
How much you're paying every month now?
5,000.
What was the order of the trial court?
10,000 was the order. And we have sought for the modification and we have also produced all the documents, ITR.
Is submitted by the land council for the petitioner that so far at 5,000. They have paid all the arrears and are also continuing to pay every month 5,000. The same is not denied with the land council for the respondent. Till the next date of hearing, trial court shall not proceed with the executing board shall not proceed with the execution. Lead from part third, pose this matter after vacation.
Much obliged.
11. Harshavardhan for petitioner, Shobha HK for respondent.
I filed the affidavit.
I filed the affidavit in the evening. You filed the affidavit?
I have filed it.
We'll
And a
hear
copy
this-
is also served.
We'll hear this in the afternoon. Yes, next. Next.
Cell number 12. Cell number 12,
Petitioner reported.
Nagraj B. S. Sarvana for respondent.
In past two occasions, the respondent has not appeared before the.
Not appear.
Not appeared. So direction of the Sama
No
court.
representation, yes. We'll hear in the afternoon, we'll pass out. Yes,
Or
Cell
Monday,
number 30,
or Monday, after some.
Monday. Monday there is, then next Wednesday you said, Wednesday we'll have it. No representation on behalf of the respondent. Pose this matter on Wednesday.
25. Cell number 13,
Behalf of the petitioner.
Anupam Agarwal for petitioner, Pratima SK for respondent.
Petitioners filed seeking setting aside of the interim maintenance order filed by the family court, my lords.
How much is
See,
granted?
My lords, please, Adit Munche, one submission, my lords. The order is that 10,000 towards the wife and 15,000 towards the daughter. At the time of passing of that order, there was already another maintenance order passed by third additional family code in criminal miscellaneous, my lords, section 125.
How much?
25,000. And that 25,000 is being paid regularly till date.
Is it so?
I'll just come to that.
No,
I'll just-
is it that fact is correct?
Yes, that fact was brought to the notice of the court also. From the time the child is born, the father has disowned the child. In fact, he does not even know how the child looks. From the time she is pregnant, in
Oh,
fact.
What is the income of the husband?
My lords, 5 lakhs, my lords. He is working with his brother as a sales executive, that's all.
They,
Brother's own business is there.
No. However, he's working, his monthly
3
income
to
is,
5 lakhs per annum, my lords.
Huh?
3 to 5 lakhs per annum.
then how the court has come to the order?
Miller.
My lords, MC section 24 order is at annexure 8.
May I submit?
Page 29.
Yes.
First kindly.
Yeah. Your Lordship, there is no justification given by the trial court in the family court. What was
Sir,
the?
please
reasoning?
read so that the court will understand.
There is no reasoning for coming.
Page number 31, please come to that and
Page
read.
number 31. Yes. Produce the application under section 24 of the Hindu Marriage Act seeking maintenance for 50,000. With affidavit, based on the affidavit filed by the respondent, where she has.
Since the petitioner failed to appear and disclose his income, the court has to draw adverse inference against him that having sufficient income. What is wrong with this finding?
Your Lordship, I am not even disputing the amount also.
What amount you're not disputing?
The 25,000 which is passed by the lower court.
Hmm.
What I am disputing is the fact that in the one case, in this,
If your income as you're stating is 5 lakh, how will you pay 25,000 per month?
Your Lordship,
25,000 into
he
how
is
much?
managing the things with his brothers and family members as a family thing. What is the issue before this honorable court is that because of the natural justice, what has happened in the criminal petition, CMISC 125, the trial court has passed an order of 25,000 for the maintenance of the child, which I have not disputed and not filed appeal. I have been paying regularly, although it was not regular, but I have been paying.
Yes.
Now what has happened that in the divorce petition proceedings, the respondent has filed a section 24 application for maintenance. In that in that application, the trial court has passed an order of 25,000 once again against the.
No, you were saying that there is a mention about 25,000 in the order. Where is it?
No, my lords. I'm talking about the
25,000.
assets and liabilities filed in the MC
The
case.
court, where is the consideration?
Your
Let's see
Lordship
that-
Court feels that 25,000 is a necessity and that's what the court has granted.
Yes. My
Then
lord,
where
she-
is the, no, not about that. There should be a finding in the order. There is nothing has been considered.
But it was brought to the notice, my lord, with the order, in fact.
Where is the order? Let's see.
Which order?
In the order, it do not contain.
Yes, my lord, that I do agree, but then it was brought to the notice of the court with the
That we have
affidavit of
to
assets and
understand from
liabilities.
the order. Now, if the
What
court
is-
feels that in spite of 25,000 what she is getting, again, she asks for another 50,000. Court grants 25,000. Is it this 25,000 granted, including this 25 or considering the 25?
Yes, because the order was,
by
no,
looking
correct.
at this-
I do understand that
Yes.
it is not reflecting in the order. My
Should
lord,
be
if I may
reflected,
just
yeah.
allowed to make a submission. What happened is after filing of the divorce petition,
Paul, there is no finding with regard to the income on the ground that he has not filed this statement of assets and liability.
no, he has not, in fact, he
When the
did not
court-
even
no,
appear,
no,
my
when the
lords.
court says that it is 25,000, that's what he's liable to pay. Whether the court was conscious of an order which is passed by the in the criminal matters, that is
I would say
important.
yes. Yeah, I would say yes, because.
No, because
I
so many
filed-
things will be stated in the papers, whether the court has.
No, my lord,
taken
this is a
into-
certified copy of the
No, I'm not
affidavit
saying that some
assets.
as a statement of assets and liabilities are filed, so many
With
things will
that,
be
yes,
stated.
I also filed the
Consideration
order.
is how the court has considered is the question.
Definitely the court has considered because I filed the certified copy of the order in CMS
Can't
along
assume
with
that.
my
Can't assume
affidavit
that.
of assets and
Because
liability.
if, no, she asked for 50,000. Court has without any basis has granted 25,000. There is, because he has not filed a statement of assets.
Yes,
To that
and he
extent, it is
did
fine.
not appear also.
To that extent, it's fine. No, the other 25,000, where is that the court had considered? According to the court, it is only 25,000 is a requirement. That is
Because
already
it's not
paid in that.
reflecting in the order. I do understand what your lordship is putting across, my lords. But then the fact is, the mother is right now suffering from various issues, health issues. And in fact, the party as well as the council are also aware of that because she can't even stand. That is her situation. So she has no financial this thing at all. For the child who is put in a good financial, educational institution, she is spending more than 3 lakhs per year, which is at least taken care in the CMS. But for her, she has to depend on her aged parents, and her father is a heart patient, and she has absolutely no
No.
financial.
It's about the
Support.
consideration is what is important.
I do understand what the court is trying to put across, no doubt, but then it was brought to the notice of the
Court
court.
has to see, like, already she is having 25,000.
Correct.
That's the court's.
Because it was brought to the notice, yes.
25,000. She requires 25,000,
Milords,
which she is already getting in a criminal miscellaneous.
No, Milords, she is not getting. That is only for the child. She is not a
Lordship,
party.
I
at all.
come to
It's
the
only for
other
the child
point.
that is awarded.
come-
I have the order, I can.
Your lordship can
same as
see
I'm
the
talking.
page number 32.
Again, for the child, it is granted now.
Again,
Milords,
it
that's
is
the
granted.
reason
It's
I-
a double payment. It is
No,
a double
that is
payment
the
for
reason
me.
I'm saying, because the child, she's spending more than 3 lakhs for the child itself.
Where is that?
Because it's in a
consideration
reputed
that, she
school.
is spending this much of money. This is all her
Because
requirements.
her affidavit she has filed as assets and liabilities, and
That
he
she will
failed to.
file, but the court has to consider, without considering these kind with this
Because
kind of a cryptic
also-
order, the court can't dispose of the matter.
Plus, also in his cross-examination recently, he himself has admitted that, yes, he has not paid, he has not taken care, nothing. That is in the MC recently. I could produce that also, my lords.
Yeah, Lordship, the question is that how can a double maintenance can be awarded and the petitioner may be asked to pay.
Were to be seen.
I am not disputing on the amount which is with reference to criminal miscellaneous 25,000.
That is to the daughter.
Daughter, acha. In the
Then you have a responsibility to maintain the wife or not.
wife also, I am not disputing that also.
Then
What
how much to the wife?
wife, it was ordered 10,000 per month to the wife and 15,000 towards the daughter. Now, my issue is that when I am already making a higher substantial amount
Then
to
it has to be, then we'll restrict it to the wife.
wife only, this is my prayer.
So your lordship feels.
Please come.
And
Because
stay
may
with reference
may
to-
What
the
about the
husband
arrears?
be directed to pay some, nothing is paid to her. So she is in dire straits. because-
When is the petition filed?
Because that is filed in 2017.
2017.
17.
So at 10,000 from 2017 till now, when are you going to pay the money?
Your lordship, if I be
If you
granted,
want an order to be passed reducing this 15,000, you have to comply with that 10,000 order from the date of application till now. When do you want it?
yes, lordship, I would definitely need some installment, some, if at least the areas I can make in another 6 months. And I can
Why
make,
no, at this 10,000, no, we'll pass an order, not the order, that if calculating only the wife's maintenance at 10,000, what are the arrears and how are you going to pay? By way of an affidavit from your client, you file
Yes,
you
Your
place
Lordship.
it before the court.
yes, I
And
will.
accordingly, we'll pass
Will
an order.
pass it.
But the learned
Yeah.
counsel for the petitioner submits that in respect of the daughter, already there is an order of maintenance of 25,000. When it now by way of the present order, 10,000 is given to the wife and 15,000 to the daughter. Now he is made to pay by 2 courts to the wife, to the daughter at 25,000 and 15,000, considering the submission of the learned counsel for the petitioner. Now, as far as the wife's 10,000 is concerned, he is not disputing the same.
Mhm.
So at 10,000, right from the date of petition till now, what is the amount? And when is he going to pay that amount? By way of an affidavit, he shall state before the court. Basing on that, the orders will be passed.
Your lordship, there is another application which the respondent has filed that they are not ready to proceed further in the divorce proceeding, since the payment on this
He's
order
talking
is
about the
not
stay
paid.
application.
Your Lordship, those
That was filed last week.
applications should not be entertained by the lower court, and that application should be.
Please understand, court will not because both of you are before the court, that doesn't mean that every application court will deal with it. Whatever is questioned before the court, that only can be looked into. When will you file the affidavit?
Your Lordship, another 2 weeks, I'll file the.
For filing an affidavit, you don't require 2 weeks.
He is
Pose
not
the
in
matter-
Bangalore. He is not
pose-
in Bangalore.
First,
First. Okay, Your Lordship, I'll.
pose this matter on 1st of October, no further time will be granted. If the affidavit is not filed by that day, orders will be passed. based on
Lordship,
the-
stay of any action, any coercive action by the
There is
trial
no
court.
coercive action taken. in-
Till 1st of October, they should not, no execution. They should not press on the execution.
Till number
Yes.
14.
Grateful.
Thanks.
Mr. Dhanush. Mr. Dhanush for petitioner Narendra Babu HL.
Yes. Yes.
Lord, we have filed an application challenging the order passed by the trial court for granting the interim maintenance for the wife.
It's granted.
10,000 per month is granted.
What is your income?
There are certain technicalities and suppressions which the wife has made before the honorable
You
court.
tell that court and then you can tell the suppression. What
My
is your
income is up to
first?
50,000.
Huh?
50,000.
It's only wife, 10,000?
There are no issues born out of the wedding.
According to you, is she working?
She is working.
What is the evidence placed before the court?
There is evidence. And there are other technicalities also, my lord. The assets and liabilities was placed on the court after Rajnesh was Neha was passed. That was in 2023. Whereas the interim application was of the year 2019. Thereafter, my lord, when the parties appeared before the court, it was referred to mediation. After mediation, there were series of lockdowns which happened, due to which till 2022, the application was not considered at all. At 2022, the Rajnesh versus Neha was passed. Then they filed the defective affidavit of assets and liabilities. We say that this is a defective format of assets and liabilities. Thereafter, they go back and take 3 to 4 months to file proper assets and liabilities. Thereafter, we will file the assets and liabilities, and then the court comes to a conclusion that husband is liable to pay 10,000 rupees without considering the facts which we have placed on record. Throughout the thing, my lord, we are saying that she is suppressing material facts. The date of marriage is wrong. The date of separation is wrong. She has deserted me in 2019. She has deserted me in 2018. Till 2019, whenever I filed divorce, she never approached the court at all. As per her records, she says she was separated in 2016 itself. That was 3 months after the marriage.
How
Till
are those,
2000
how are those relevant for interim maintenance?
The interim maintenance is granted.
Let's assume that
Please.
there is some mistake in the dates and all. It will be decided by the court in the pending MC or whatever it is. As
Please,
far as the maintenance is concerned, no, the petition from the date of her petition, she'll be entitled for maintenance, whatever is
Please,
granted.
my lord, please.
Now, whether she's working or not is the relevant factor now.
Yes, madam.
For that,
Suppression
what
of
do you
material
say?
facts.
What is that?
I have a document for that, my lord. And other thing to be considered is that, my lord,
First on that, please show that.
well, because I was appointed as BESCOM employee on compassionate basis. I have filed my divorce petition that she was.
On the first submission of yours, you substantiate the same by giving the document which you're relying on.
Please.
Have you given him a copy of it? You should have filed it if you have the documents, sir. And
Lord,
should
they
also
came
give
on
the
the
other
court
side.
only on the previous date of hearing.
You have given him?
They came on record only on the previous date of hearing because, my lord, we have approached this honorable
You have
court.
been filed before the registry, not
Lord.
when the matter is reached.
Please, if it can be seen, my lord.
Where is that she's working?
Document number 3, page number 27. We have filed an RTA application. Document number 3 of the memo, page number 27. That is an RTA application which was filed before the field officer. Thereafter, he gives a reply in page number 28, next page. Chaitra Han, who has performed as guest teacher from 24/8/2022 to 31/3/2023. This is one of the works which she was doing, which she has suppressed from the court. Her assets and liabilities, if it can be seen, my lord, it was filed in.
My lord, insofar as this document is concerned, I'll seek instruction, but in the very same document, please, my lord, which I would like to bring
The
up.
petitioner had placed documents before this court stating that the wife is working with the said aspect was suppressed by the wife, then counsel for the petitioner submits, respondent submits that he'll get instructions on this aspect. The respondent wife shall file an affidavit before this court.
And I'll. in the
Lord,
same
another one
document, it
point is
would
that, my
say-
lord, on 2023, July, when we appeared before this honorable court, we were directed to serve upon the respondent counsel and the petitioner. She was very well aware of the proceedings before this honorable court. Until and unless the matter was taken up for final hearing on the previous set of hearing, they never chose to appear before this honorable court. Only now they are appearing before this honorable court.
Yes. When will you file?
And now they are filing execution proceedings before the trial court, and they are choking me to file the
Last
maintenance.
occasion, my lord, I made a submission that I'll not precipitate the execution proceedings.
That may be extended, please.
On the last occasion, land counsel for the respondent has submitted that they'll not precipitate the execution proceedings. The same is taken on record. Pose this matter.
27th, please.
Yes, file
Please.
affidavit. 27. Yes, next.
Cell number 15. Sanjay Nayak for petitioner. P.S.
The
Subbarao.
parties are in discussions of terms of settlement. We posted after vacation.
Lordship, now four months have elapsed from this settlement issue.
Then counsels of both the parties submit that the compromise talks are going on. That is on third.
One date may be given to us for mediation, please.
No, that's on 13/9/2024.
The lower court, they've been passing on the dates for evidence as well as executions also there. Both have been stalled, saying that it's pending in the High Court, and we are trying to settle. Nothing is happening. 4 months, 3 months.
According
for-
to you, what is the settlement and how is it
There
going on?
was terms which was emailed to the respondent.
After
He's
3 months.
responded today morning. He's responded today morning. We are yet to receive that email from the client, and we have to discuss with the client and update back to them. So
Kindly give one date for mediation, please. We'll sit across and settle it.
any
Bangalore
date
Mediation
after
Center.
vacation, if we
When-
can settle it. Any
When,
date
when,
after
when will you
vacation.
Next
go
week.
for the mediation center?
Next week.
Mediation, I have no instructions.
No, when you say
No,
that
she's
you are
there.
interested for a settlement, why not mediation? Mediation center, there you go and settle.
Please.
Which day?
Monday. Monday, 3 o'clock. We all finish by Monday, 3 o'clock.
Next
He has
Wednesday,
to,
I'm good.
he has to ask his
As
client.
the
his
client, they
client
have
should
to be
there.
available for mediation.
Lordship, three
If
three
it's a
months.
court, I can come myself.
Get
but in-
instructions and
yeah.
ask your
This-
client, when is the date? We'll pass orders in the afternoon. Yes.
Oblige, please.
Cell number 16 urgent. Cell number 17.
We are for
Cell
appellate in
number
this case.
17.
Respondent number has died, my lord. We filed a LR application, my lord.
You find
Yes, my lord. Already filed, my lord.
notice
They
is
have to
ordered.
file
in the petition.
objection to the IA.
Yes. Are you taking notice for them also?
No, I
Notice
have to
served,
verify,
my
my lord, it has.
Uh,
I will have to verify.
Yes, sir.
it is not served on him.
Served, my lord. They filed wakalat also, my lord.
Wakalat.
5A to 5C, they filed wakalat. No, objection is not yet filed
Objections to what?
to IA, my lord.
Objections to main, I have already filed.
Not main.
Even-
What objection you have for that LR petition? You have any objection?
R5.
Notice is ordered in that.
Issue notice
Please
on
give that,
INR.
give that.
No, I will have to verify because it has come for, nothing is there in the cause list, my lord.
Notice to Arvind.
Issue notice on IA number 1 of 2021. What happened to that notice?
There is no reference in the cause list, that's why, otherwise.
That's why the registry is too busy not to mention anything. You want to file, yeah,
I will have to verify, my lord, because,
yes.
because only R5 I am
And
representing.
counsel for who died?
Please, ma'am.
Who died?
R5, my lord, sir.
Then what is,
R5.
Yes, ma'am. R5, sir, wakalat kuda hakide.
Mr. Counsel, please check the court file and please submit, pass over.
Please, ma'am.
Cell number 18. Ramchandra Iyer for petitioner. Appellant. VP Shivkumar for respondent 1.
This occasion, there are some developments in this facts of this case. Your Lordship. It's an order 39 rule 1 and 2, which was rejected, and order 39 rule 1 and 2 filed by the appellant also, which was rejected, and their order 39 rule 1 was upheld, Your Lordship. Now, the change in circumstance, Your Lordship, on the last date, I filed, placed some materials on record, which shows that RERA has come into force. This particular project where construction has taken place, RERA Act is applicable to this case. In view of this, I filed an Order 7 Rule 11 before the trial court, which is posted for orders on day after tomorrow, Your Lordship.
The court will decide it independently. What is the connection between that?
And there's a writ petition, Your Lordship, where I've challenged the
No,
modification.
if once the court gives a finding that it comes under ERA and so that's not maintainable, then accordingly this order will go with that.
And one more, Your Lordship, there is some,
Why a 2017 writ petition? No, what is the significance of an injunction petition now?
one more aspect is that there's one judgment, writ petition have challenged the modified sanction plan. In that, Your Lordship, on the last occasion, I filed one memo where the court has made some observations which will have some bearing on this case. I have preferred a writ appeal on that order, it will come up anytime now in this week, Your Lordship, or the coming week. So I request for a short account.
What all he says is, has any.
Correct. Those aspects are correct.
I'm not saying that he is making any false submission. I'm saying for deciding this MFA, how are those relevant?
May not be relevant because this is, permission is granted to proceed. to
Want,
put up
at any
construction.
cost, you want to keep this appeal live.
They want it. I don't want to keep it alive.
It
No,
will
he's
have-
the appellant, I'm referring to him.
Please.
will have a bearing, Your Lordship, because the learned single judge in the writ court,
What is the, when the appeal is going to come?
Lordship, I've already served them the copies. I've moved a memo also. Next week it will come up, Your Lordship.
The request of one counts for the appellant.
In fact, the
This matter
constructions
after
are
vacation.
completed in all respects.
Post after vacation. On 29th of October.
Cell number 19,
29 of this month.
October.
Much of.
Yes, Sudhindra for appellant, Subramanya, yes.
I move
They
for
be for
the
the respondent.
First,
appellant in this case, my lord. The last, see, this is a suit for bare injunction filed before the trial court. My client's contention is he has purchased a site number 102 from survey number 56. And the defendant, they claim that it is site number 1 formed in survey number 57. It's a border case. So when the suit came to be filed before the trial court, the defendant has just started the digging work of the foundation. They entered a caveat. I could not get the ex parte interim order. The matter was adjourned for filing of the objections. Unfortunately, for my unfortunately, the presiding officer was deputed, it appears, to the Judicial Academy for training. So it came up before in charge court. So again, they took time to file objections. The in charge court did not evince interest in disposing the matter. They proceeded with the construction. Now, when the matter came up before this honorable court, they had completed the construction of ground floor. And there was an interim order not to put up further construction. This is how the matter stands. In fact, I gave a proposal to my learned friend. See, my client has spent more than 12 lakhs. If you pay the cost, we will give our interest. But he is not evincing interest. He says that only 5 lakhs my client is prepared. And the suit before the trial court, I have converted the suit into a declaratory suit, paid the ad valorem court fee, and also sought for mandatory injunction. Even now, it is left to my learned friend.
No, first of all, in the light of that mandatory injunction and the subsequent development,
Please.
what is to be decided in this MFA?
Nothing remains, bro. In this matter, I'll come to that. I'll come to that. See, in fact, you use your good office, prevail over client, at least to be reasonable.
What are your instructions?
Lord's McKindy, see paragraph number 12 in.
No,
page
your
number
instructions on that, what the senior counsel.
My
said.
clients are 2 clerks, one in Canara Bank, one in the income tax department, husband and wife. They, with all their life money, they constructed a house. And the dispute they are now saying is that it comes in survey number 56. And none of the documents produced, trial court recorded a finding. It says it comes in 56 even. And my clients, they are demanding a money around 12 lakh rupees. They do not have this money. The problem is like this. They say to even we wanted to buy peace. But the problem is, Lord, see, he comes and creates a trouble without having any document. And there's virtually no document with him, except a sale deed that he produces. And trial court had recorded a finding in paragraph number 12 that what he is saying, that survey number 56, that his site falls in. There is no prima facie material at all for that.
Let's see that.
Paragraph number 17, page number 17.
No.
Senior counsel.
McKindy, Lords, McKindy.
Yes. Let's just look at the plaint. What is the specific case?
Lord,
This matter is, can be short, in short question, it can be disposed of. I filed a memo on the 24/7/2017, saying that I'm not going to claim
in fact,
equities.
one more proposal I would like to
Succeeds in
do
the
at the
matter.
instance of my client. He says, see, they have put up construction. See, my client is prepared to pay 50 lakhs. Let them give the property. If they are facing lot of difficulty, it's a property
It is
worth
residence.
more than that.
How can you sell it off and go? May I make one suggestion, at least because the Reliance in the council is making. Let the matter be posted to mediation. I try to keep the client even present. If he wants to have a talk over there with them,
Yes.
whatever he has with us, let him talk to them once.
Even otherwise.
I have no objection on
If
that.
his clients
Because I
come
am not
before
coming
this
in the way of
honorable court
settlement.
also, this can be thrashed out.
Counsel for the, please come, then counsel, then senior counsel acquiring for the, but the appellant submits that there's a scope for mediation. And the land counsel, the respondent also submits that the matter may be, matter may be referred to the mediation. Party shall appear before the mediation, Bangalore Mediation Center on which date?
Any given day. They have to-
Any immediately after.
Second, madam,
this-
second.
Second,
Holiday.
madam.
Holiday.
After vacation.
Yeah, after vacation.
After vacation, any day.
14th October?
Mechanic, 14.
Much
14th
obliged.
October, Registrar
Okay.
Judicial is, they shall appear before the mediation at 3 o'clock. The Registrar Judicial is directed to communicate this.
Much obliged.
Mechanic.
Serial number
Alright.
20. Samarth Prakash.
I seek that I be permitted to retire from the case. File has been taken away. I don't have the file, my lord. I've sent a notice to the appellant. I'll file this in the registry. I may be permitted to retire and my name may be deleted
No,
from.
no, first file it, then only we
Please,
can.
please, please.
Land counsel for the appellant submits that. He has no instructions from the client and he has already given up the, he has given given all the papers to the client. And he's going to file a memo of retirement. When?
Right away, ma'am.
Post this matter on 25th? Yes.
Serial number 21.
My lords,
KBJ.
appearing for respondent number 4, my lords. Lords, we are filing a document in this, my lord, requesting 2 weeks adjournment.
Which
My
case?
790 MFA.
This is 21 is going on now.
Chandrasekhar Patil for respondent.
Yes, my lords. We are for respondent number 4, my lord.
Hmm.
We are filing a document in this, my lord. We are requesting
What were you doing? What were you doing all through? It is submitted at the land council, the
My
respondent.
lords, we are upright.
Post
My
this
lords, we are
matter on
upright for
29/2024. Then the court has made it clear that no further adjournments will be granted.
My lords, we are applied for a certified copy in this, my lords.
That's not the court's problem, Mr. Counsel.
Before that also they have
Come to the
taken
court,
for.
come to the
My lords,
court and
I'm
argue.
a week time, my lords.
Huh? Will not adjourn the matter. Every time, this can't go
No.
on like this.
My lords, this is the last time, my lords. A week time may be granted, my lords.
What was the last occasion? It was not last.
Sorry, my lords.
No. Last occasion was also a last adjournment.
No, my lords, there is for compromise. It's compromise, my
No
lords.
compromise.
Already they are.
No, my lords,
submitted,
that's why we are
Please
for.
argue.
4 days.
Post this matter on Wednesday. No further
No, my
adjournments
lords,
will
that
be
is why we
granted.
are filing in documents, my lords.
Whatever you want to do it by Wednesday. It will come. And that even if you don't come also on that day, we will hear her and pass orders. At the
My lords,
instance of
my lords,
the
maybe on
counsel
Thursday,
respondent, the matter has
my
underwent
lords, Thursday, my
adjournments.
lords.
Today also, again, the counsel for the respondent is asking adjournment. It appears that on one pretext or the other,
It's maybe on
the
Thursday, my
respondent
lords.
is not interested to pursue with the matter. Post this matter on Wednesday. By the time, if the respondent is not
No,
ready
my
with
lords,
the
Thursday,
matter,
my lords, my lords.
Thursday, by the day, if the respondent is not ready, the matter will be heard and orders will be passed.
Oblige, man.
Yes. Follow me.
Serial number 22 urgent. 23.
Lord, appear for the appellants. Kindly permit to make my submissions at 2:30 PM, my lords. I will appear physically.
Yes, you ready?
Please.
Yes. Pass on.
Serial number 24. Ramesh Kumar.
Pass out senior head up in some other court. Pass out.
Get up.
Serial number 17, my lord, just now passed. That my colleague has filed a wakala, but anyway, my lord, the IA has not been put up. It has to be allowed and amendment has to be carried out. So direct the office to.
They'll get it, get that IA. IA, let it be placed, will allow it by again, another adjournment for that.
Please.
No adjournments now.
Passed away, so. yes.
Which case?
Serial number 30. 30. Yes. Seshadri NS.
It is submitted that
For
there's inconvenience to the council for the petitioner. Post this matter after vacation on 21st of October.
ಯಾವ್ದು? serial number 30 exam ಆಯ್ತಲ್ಲ ಅವ್ರಿಗೆ. Last ಅವರಲ್ಲಿ ಇದು ಇವ್ರದ್ದು ಪಾಸ್ ಅವ್ರು ಏನಕ್ಕಾಯ್ತು? ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ ಸರ್? ಬಂದ್ರ ಅವರು ಬರಲ್ವಂತ ಹೇಳ್ಬಿಡಿ ಹೆಂಗಂತ. ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್ ಈಗ ನೋಡೋಣ ರೀ ಯಾವ ತಗೊಳ್ಳಿ ಅಂತ. ಬಂದಿಯಾಗ ಇದು ಸೇರಿ ಮತ್ತೆ 5 ಎಲ್ಲ ಮೆಮೊ ಲಿಸ್ಟು ಎಲ್ಲ ನಿಮ್ಮ ಇನ್ಶಿಯಲ್ ಹೇಳ್ಬಾ HS RHS 5 times ಆಯ್ತು. ಫಸ್ಟ್ ಪಾಸ್ ಅವ್ರು ಇವ್ರದ್ದು ಇರೋದು ಅಲ್ಲ, ನೀವು ಫಸ್ಟ್ ಪಾಸ್ ಅವ್ರು ಇಲ್ಲ 2:30 ಇದೆ ಸರ್. 2:30 ಆಗೋಗ್ಬಿಡುತ್ತೆ ಬೇಗ, 10 ನಿಮಿಷ 1/4 ಗಂಟೆ ಆಗ್ಬೋದು ಅಷ್ಟೇ ಅಲ್ವಾ?
Your lordship permits, I have a small request to make, my lord. In the cause first list, my lord, serial number 40. When my colleague, the opposite counsel is not available today, he told me, may be taken up after vacation, my lord. Serial number 40 in the first list.
Is it informed to the other side?
Yes, my lord, I spoke to him, in fact, he is not available today.
Yes. After vacation,
Please.
post on 28th of October. Yes, next. All the list. Then we'll go for the passovers. No, first list, then passovers. That you call first.
230 list number 2, serial number 1, DB Shivakumar. For petitioner.
I appear for petitioners, my loss. My loss have sent the retirement memo. Next hearing date will file it before, file it now.
No, what is that way of filing a retirement memo? I've seen it.
Parties are not,
No, you have to send it. There should be some communication. How will the court know?
my loss, we have sent a letter to them, my loss. Next hearing date will file it before.
Let's see. Let us see what is it. What you have filed. The retirement memo is there.
We have sent the letter of retirement to the client, my loss. Next hearing date will file it before the court.
Something they have filed the other day. They filed retirement memo the other day. That was not, then the court is not ordered. Talking about retirement. It is submitted that, not in this case, it is submitted that by the council that they are going to file the memo of retirement, retreat from the caption for dismissal and post this matter after vacation. Post on November 12th. Yes,
Serial number 2,
yes.
for orders matter.
I appear for appellant. My lord, so there is an office objection that the appellant number 1's name, there is a discrepancy, and she is also called as Gangama, my lords. In the GPA, it is written as Ganga Arasama.
Please mention the name as it is mentioned in the cause title of the trial court.
My lord,
Let the cause title be as it is, as it was before the trial court.
my lord, they were not the party before the trial court, my lords. They are the LRs of deceased appellant.
Then what is
Lords, in
objection?
GPA, it is written as Ganga Arasama, my lords. In the cause title, it is written as Gangamma.
In cause?
In cause title, it is written as Gangamma, my lords.
Gangamma.
Yeah, in GPA, my lords, it's written as Ganga Arasamma. She is also
So
called
who-
as Gangamma, my lord.
Oh, how to assume and presume these kind of
Correct.
facts?
She is the wife of the.
No, please don't tell all that. We can't assume facts like that.
Lordship, direct
Office
them to
objections have to be complete.
Copy. Lordship,
Copy
direct
to
them
be
to
served on
copy.
the garment reader.
My lord, for second respondent, central government, my lord, may be permitted to serve copy on them also. The second respondent is represented by the central government, my lord.
Excellent counsel shall serve the copy of the appeal memo on the central government council.
Much obliged.
Serial number 3. Serial number 3, memo for withdrawal.
For appellant memo, we have filed memo for it.
A memo of withdrawal is filed. The same is taken on record and MFA is dismissed as withdrawn. Yes.
Serial number 4. Anand B. Ramanwar.
I'll do the needful during the course of the day, my lords, may be permitted.
One submission. The valuation is in respect of 2 acres of land in Bangalore. Valuation is says less than 1 crore. Or it should be either above some figure, 15 lakhs, when it comes to this code. Actually, this MFA may have to go before the division bench. They will have to take that.
What is the objection taken by the office?
Objection is with respect to the IA which I have filed, my lords.
Then
That is
what
not
about the
in,
valuation?
not in,
What the senior counsel is submitting?
that was not an objection before raised before the registry, my lords. Objection is with respect to the only IA.
What you said as far as the valuation is concerned?
Valuation, there is no, it is shown as less than 1 crore, which has been shown in the trial court record.
More than 15 lakhs.
No, what is there? They will call for the valuation slip to produce.
So less.
So as there in the,
No, less than 1 crore means it can be 15 lakhs also, according to you.
it may be anything.
How can it
It may be
be?
anything, but things to
Specify
that.
that also. The petition counts for the appellant seeks time.
The petition, they have said that defendant number 1, we think that she may be dead. She is alive. very much living.
Not made.
So we are not claiming any relief against defendant number 1.
No, but you shouldn't say that. I think she might, she's no more.
No, as per my instructions, my lords, what my party says that she might be dead as on today because what she said. So in that background, my lords, we didn't proceeded with the
office
defendant number
objections
1.
shall be complied with. And senior counsel appearing for the respondent submits that when it comes to the valuation, it is stated that it is below 1 lakh.
1 crore.
1 crore. And even on that also, the office shall take in that objection also. And the same shall be complied with by the appellant. Yes,
Next week, my lords.
yes, next week. No, next week not possible. It will come after vacation. When will you do it?
No, it will be the last line. I'll be in a hurry.
Was this matter on 1st of October?
Mobilize.
Yes.
Cell number 5, Maruti Reddy, memo for withdrawal.
Non-compliance of office objections itself. Then why it is not reflecting in the paper? The more is filed seeking to withdraw the revision petition. Same dates taken on record and dismissed as withdrawn.
Cell number 6, P Nataraju,
Appearing for the petition, rest for a week's time. I will comply the.
Earlier when it has come,
for the first time it is posted for the.
a week's time, default clause. No, what you have to write is, the office objections have to be complied with within a week, or else the appeal shall stand dismissed without further reference to the court. Yes, next.
Cell number 7, Chandrasekhar K.A.
Petition, needful done.
Is done.
Done.
Then council submits that the needful is done, post after service of notice. Yes.
Cell number 7, 8. Cell number 8, Varun Kumar K.R.
No representation for dismissal
tomorrow.
tomorrow.
Cell number 9, Srinivas V.
Petitioner, my lord, I am permitted to comply today itself, my lord. English to be stitched, I will stitch it here itself. Your lordship permits, I will stitch translation copy here itself, my lord. English translation to be filed.
Do that.
I am told that it's only stitching of the English version, that's what.
Counsel for the petition not comply the office objection affidavit along with the IA copy to be furnished.
What, 2 days time, 3 days time, Monday.
Time is granted till Monday for complying with the office objections. If the office objections are complied, post the matter for admission.
Much.
Cell number 10, Anil R.
Appearing for petitioner. Appearing for petitioners, my lord.
For that, it will come in orders. Both of them are here. Same. Why don't you tell them this? When the wakalat is filed for respondent, why do they list it in orders? Was this matter for B group hearing? Yes, next.
Cell number 11. A.L. Srinivas.
No representation for the petitioner. Post for dismissal on Wednesday. Yes, next.
Cell number 12.
I represent the petitioner.
Yes.
And there were 3 petitioners before the trial court. But now the petitioner number 1 has challenged the order passed by the learned family court judge. But the office has raised objection that petitioner number 2 and 3 before the trial court are not made as parties to the.
You have to show them as respondents.
I'll make them as the respondents.
Yes, office objections to be complied with. A week's time is granted for complying with the office objection.
There is urgency in the matter, my lord. But I have sought for custody of.
No,
the
when,
children
if you tell the court
during
when
the-
you will do
during
it,
during the course of the day itself, my lord.
it's submitted that during the course of the day, the petitioner will comply with the office objections. If the office objections are complied with, pose this matter on Wednesday.
But I may be permitted to serve the copy of the writ petition on the advocate appearing in the trial court, my lord, since there is urgency.
First of all, you have to get over
I'll
this.
complain the
Then
office objections now itself.
And then pose this matter tomorrow.
Please,
Then that order will be passed tomorrow.
please, please.
Yes. Continue with the list, then the passouts.
Number 1. Case number 23. 24. Case number 24. 24 is a pass over, na? 24. Case number 25.
We'll take up the, we'll take up the matters later. Yes.
25 Ajay Rao.
24.
20?
24.
What happened to 24?
In the morning, it is passed over Ramesh.
Passed over matter will be called. Yes.
25
For respondent.
Yes.
Ajay Rao, Vijay Narayan
Excellent.
for respondent.
Just thought I'd be, like, make a submission.
Hmm.
I wanted to be fair on the court, my lord.
Huh?
I wanted to be fair on the court, my lord. So then, so it appears that there is already an MFA which is filed challenging the order, which, my lord, the clients were not aware of when we filed the appeal. Hence, my lord, I just wanted to be before, my lord, your
No,
lord.
no. How, what is this clients not being aware of? They've only filed. They must have given wakalat.
Lot of matters, my lord, I would, they didn't, only 2 matters, my lord.
They'll just stay in this.
No, my lord. Before your lordships could deal with it, I thought it would be.
My lord, they had stated in this petition, saying that this application, they have stated that they were not aware of the injunction order. And they took this injunction order dated 2020, 31/7/2020. They came to know about it in 2024. They had appeared and it's a adjudicated thing. There is a delay of 783 days, my lord, in this filing continuation delay, they have filed an application. There is no grounds they have made. They have made allegation on the advocate saying that he was not giving the copy and everything was made. So there is no such thing that, they are not aware of this thing. They had taken the written statement as the objection.
No, in the other MFA, what has happened?
It's at the stage of admission.
I'm not.
Then now you want to
I
withdraw
won't
this.
withdraw. I want to be fair, my lord.
Yes. Your client should have been fair.
Not that to their this thing, my lord, I would submit that they were not aware, my lord, that because I know them personally. That's the reason.
A memo of withdrawal is filed stating that the preferred MFA number 1606 of 2022 against orders on IA number 1 dated 31/7/2020, passed invoice number 1657 of 2018. On the file of the Honorable City Civil and Session Judge Bangalore. They were not aware of the. Instead of writing all this, no, you better withdraw this. All these reasons that are stated looks.
Take out the reasons, my lord, and simplicity of withdrawal.
A memo is filed seeking to withdraw the appeal filed with them accordingly. Appeal is dismissed as withdrawn.
Great.
Give the other memo.
Yes.
Prepare a memo. Case number
Memo
28.
is taken on record and dismissed as withdrawn. Yes.
R. Shashi Kumar for petitioner. Appellant. Umesh BN.
Engage the senior counsel. Senior counsel requested 10 days time.
26.
Interim order is there in there.
No.
At the request of learned counsel, the appellant poses matter on 22nd of October.
Case number 27. Case number 27. Ganapati Bhatt. PC Sitaram Rao.
There is, my lord, declaration suit has been filed before the trial court. That is OS number 3327 of 2024.
Filed by whom?
Filed by the appellant.
Hmm.
And along with that, my lord, 2 IA came to be filed. One is under Article 39 Rule 192 seeking restraining them to interfere with peaceful possession enjoyment of the E scheduled property. And another, my lord,
Possession of the which scheduled property?
Please, my lord.
You said D schedule,
A schedule.
A schedule.
Out of which, my lord, 19 square feet, which they have encroached, which, my lord, that we have sought. Kindly see page number 35. Schedule A is, my lord, the whole property. In page number 35, my lord.
Yes.
This kindly see schedule, all the piece and parcel of the property bearing so and so, so and so, so and so, so and so, measuring east to east to west 80 feet, on north side 84 feet, and on the western side 83.5 feet, out of which, my lord, kindly see in page number 36, B schedule property, my lord, which the prayer which is sought is, my lord, once again, my lord, kindly see that the declare that the B schedule property is the part of A schedule property as per gift deed so and so, so and so. Issue mandatory directing defendant to demolish encroachment portion of his A schedule property. This is prayer which we have sought. And, my lord, ultimately, my lord, initially ex parte interim order granted not to put up construction.
Not to put up?
Construction on this B schedule property. Subsequent to that, my lord, since, my lord, the encroachment that we have produced our documents, sale deed, kata, everything that we have produced. And thereafter they have appeared and they have filed statement of objection and written.
What is the case of the defendant? What is your case?
Defendant saying that they have got, my lord, allotted certain land from society, and, my lord, that they have not encroached and they have constructed, my lord, first and second portion floor. That is, my lord, under construction. Therefore, my lord, that they have not encroached. That is their case. My respectful submission before this honorable court and specifically pleaded. Insofar as the southern side of B schedule property, which we have sought, I have made, my lord, a submission before the trial court stating that in case if I am able, this is declaration suit has been filed that they have encroached, and there is a commissioner to be appointed to measure and to find out encroachment. That the tribal issue is there already, my lord, that the matter to be tried to come to conclusion. However, trial court, my lord, ultimately, my lord, heard both sides and said, my lord, vacated the interim order. As against that, my lord, there are 3 appeals, that's 27-28. One is, my lord, injunction restraining them to first appeal. Second appeal is not to put up construction. Third is, my lord, Order 39 Rule 4 application, which we have filed appeal. My respectful submission before this honorable court, before arguments, if they are undertaking before this honorable court, if I am able to establish that this 613 square feet is, my lord, encroached by them, then, my lord, they can file affidavit before this honorable court that without claiming equity, they will, my lord, hand over demolished portion. Then, my lord, suit may be disposed of within 6 months or whatever your lordship decide. That is your lordship's.
First part of your submission is acceptable,
Please,
not the
please,
second
that
part.
is by virtue
Yes.
of Supreme Court, my lord. Yeah,
Not by virtue.
even otherwise,
we
you are.
cannot whenever is.
I
No,
received
ultimately
copy of the.
that has to follow. No, whether you say that or not. No, once the court comes to the conclusion that he is the owner of the property, you have encroached. Encroachment has to be removed.
Before making my submission, Milords, I received a copy of the IA day before yesterday. Objections are ready. I'll file it in the registry
Objection
today.
letter filed. I'm arguing now.
I have given him a copy. Milords, the appellant, this is a luxury litigation so far as the appellant is concerned.
That has to be
Appellant is
decided.
running a petrol bunk in his property, and the extent that he has shown to Indian Oil 9 years ago before setting up the petrol bunk, he is in possession of the entire property. His compound wall is undisturbed. I have been allotted, my vendor was allotted site number 190 measuring 60 by 80, which is abutting his land. I have been put in possession since 1986. My compound is existing. I have produced photos to show that his compound is intact. My compound I have removed. There is no encroachment. They don't even say when the encroachment happened or when.
Please understand.
Even the cause of action is a false cause of action.
Please
They
understand.
come before the court.
No, please understand. No, there is no encroachment according to you.
Please, no.
Then even if the court says that in the event, if he succeeds if the court is you are so confident about your documents and all. So what if this order is passed? What are you going to lose? That in case if he succeeds, you have to.
Yes.
I agree.
That is not it's not a restraint order.
I bow down to your lordships. Manoj, but the malafide of the appellant has to be looked into before such a order is passed, my lords.
What
He
is
says,
the-
my
let
lords,
us-
I started putting up construction in the month of May
No,
2024.
let's look at the order.
Yes.
Let's look at the order. What are the reasons that are given by the court while passing, while dismissing his application?
Court straight away said, my lord, that they have started putting up a construction. Therefore, my lord, that it is vacated. Kindly see reasons, my lord, starts, my lord, para 9. Para 9, my lord, ink page number 26. It is also necessary to note that the photographs produced by the defendant show that the structure of the ground and first floor had already been completed. Though the plaintiff has contended that the construction was in initial stage when the suit was filed. The photograph produced by the defendant strongly probability is that structure has been come up before filing the suit. The plaintiff has to approach belatedly. It appears that plaintiff has not disclosed real stage of the construction at the. My lord, this is, my lord, when I have clearly stated.
Paragraph
my lord,
10 may also
I have
be read, my
clearly
lord.
stated,
Paragraph 10 may also be kindly read.
I'll show.
In view of the
If
reasons.
he has not encroached, what is the wrong in it to file affidavit if I am able to establish by appointing commissioner? I am not stalling now. Definitely, my lord, that they kindly see the plaint which I have produced.
No, it's paragraph 10, I'll read.
Yes, I'll show my documents, cause of action which is pleaded.
The compound wall which the appellant put up 9 years ago is undisturbed. Where
That
is the
is-
question
that-
of,
that-
where
that-
is the question of
They have
encroachment?
demolished on southern
Come to
side.
Please wait, come to para number 11.
11 minutes. If the defendant is prevented from putting up construction, it will cause, it is the balance of convenience which is discussed here, Manoj. Manoj, they come to the court saying that I started construction in the month of May 2024. Manoj,
No,
it is not an
Once
empty
you
site.
establish before the court that it's a luxury litigation,
Please,
and without any basis they have come. All this has to be decided during the course of the trial.
Please, Manoj.
Is it not?
Manoj, may I make one?
At this stage, no, there is no order against you, but for which has to follow necessarily, even if the court do not pass such
Manoj,
an order.
may I make one request, Manoj?
If he
I
objects,
will
Manoj,
board out.
please.
I will take instructions from my client and I will file an affidavit if required, Manoj.
No,
In the meanwhile, Manoj, may I make one
court will
request?
record that.
Manoj,
Court will pass an order.
Manoj, one request in that
Not
case,
with-
Manoj. Manoj, I have been allotted 60 by 80 site, Manoj. I am in possession of 50 by 80. 10 feet by 80 feet
Right
is
or wrong,
encroached by
right
him.
or wrong,
800 square feet has been encroached by
counsel,
him.
please
Let him also
understand.
file an affidavit that in case it is held, that my site is only 50 by 80, I'm in possession of only 4,000
No,
square
you
feet.
have said.
As against
I'll
4,800 square
show.
feet, he will give up part
I'll
of his
show
petrol
it in
bunk.
the statement. I'll show what is the documents which you have produced. That see, he has.
There should be some semblance of bona fides when he comes to the court. When his compound wall is undisturbed, he should not say I've encroached, or he should say when the encroachment
let them
happened,
stop
or where the
construction.
encroachment happened. My compound wall is 35 years old.
You're not understanding. How can all those be decided now? Without going into the trial? We are at an interlocutory stage. It's an IA. No order against you. Why are you bothered about it?
It should be both. It should be both ways, Manoj.
No. If you have a strong case, why are you? No, there is nothing against you. By saying this, in the event if he succeeds, you shouldn't claim equities. What's wrong in it? It is not against your client. Now, as of now, nothing is going to happen. And after the trial is come, after a full-fledged trial, when the suit is decreed or dismissed, at that point of time, this will be considered. Please come.
Let's one last.
Yes, tomorrow.
Re-
Get instructions from your client. Yes, tomorrow.
Cell number 28.
Blood. Monday. Because
Let him come and court will dispose of only on that, nothing, no more arguments on that.
a direction matter to argue before.
Huh?
One direction matter is there, therefore
No, your presence is also not required. That's the only thing. Court will only record that. Yes.
3 appeals. Madam.
Yes, 3 matters tomorrow.
Much.
Yes, next.
28, 20. Cell number 30 adjourned. 31. Syed Abdul Sabur,
Petitioner in this case, my lord.
Appearing for respondent in this case, my lord.
Yes.
Petitioner and respondent got married in the year 2014, my lord.
Hmm.
After the marriage,
What is the maintenance granted?
7,000, my lord. 7,000 only,
7,000 to the wife.
my lord.
Hmm.
But the respondent is earning more than 40,000. He is working in Air Force, my lord. He himself has admitted in his statement.
Please come to the order. Straight away come to the order. And start reading from the reasoning part.
The respondent has not produced any material evidence before the court to show that the petitioner herself has the matrimonial house. There is no evidence to show that he has made his effort to bring back the petitioner to matrimonial house. But the evidence reflects that he has filed petition before the family court, Bangalore, seeking dissolution of the marriage. The respondent being the husband of the petitioner, he has not made any arrangement for the livelihood of the petitioner. And the petitioner has no source of income. It is duty cast upon the respondent to maintain her according to his status. But he failed to discharge his legal and moral duties towards his wife and totally neglected her to maintain, though he is having sufficient source of income. With the above discussion, I am of the opinion that the petitioner is entitled for a maintenance from the respondents. By looking into the status of both the parties, I am of the opinion that it is reasonable to award 7,000 per month to the petition for her maintenance, so that she can lead a simple life in a dignified way. Accordingly, I answer point number 1 and 2 affirmative. In order sheet, my lord, he himself has admitted in cross-examination since last 5th. Shall I go through that, my lord?
So you're saying 50,000, but it shows it is 28,000.
It is 40,000, my lord. In cross-examination, he himself has admitted he is working in Air Force Central Government, my lord. He has not produced.
Looking at page 15, internal page 9.
Yes, he has saying that, and I have.
No, where from you're saying that it is 50,000?
40,000 per month.
Where from?
It is an order sheet, my lord. I have a. Page 707.
That is his present salary. That is which year? No, I think you. MC, his evidence is this.
Yes, ma'am. Since last 15 years, I am working as a MTS attender in Indian Air Force at Bangalore, and my present salary is what he himself has admitted. But he has not produced any salary certificate before the court.
Yes. Even in MC also maintenance is granted.
No, nothing. It is divorce has been allowed, and I filed an appeal before this honorable court.
What do you say?
My lord, the Honorable Trial Court has rightly granted 28,000, my lord.
What
And
is your salary? Your salary is 28,000 or 40,000?
my lord, as per the instructions received from the client, it's 28,000, my lord.
But what about this? Have you not seen this page?
Yes, my lord. I'll take instructions on that aspect, my lord.
The request of non-counsel for the respondent poses matter and appeal the portfolio. By the time she shall get specific instructions with regard to the salary. Yes.
32, 33 adjourned, serial number 34, Prasanna VR, petitioner.
Husband's petition was against the interim maintenance.
How much is granted?
But 10,000 to the first petitioner.
First
and-
petitioner is wife.
Yes, Minos. And 20,000 to the second petitioner daughter.
What
But
is the
the-
age of the daughter?
The daughter, my lord, married about 10 years, my lords. 10 years.
27,000 is granted. What
30
is your income?
30,000 is granted in all, my lords.
What is 37 plus 20?
My lords, 10,000. First petitioner is awarded with 10,000.
10,000 and 20,000.
20,000.
And what is the salary of this?
My lord,
petition?
my salary, my lord, is about 1 lakh, my lords, out of which 70,000 will be, my lords, installment for loan. Housing loan I have availed, my lords, when the wife was residing with me. Wife was left, my lords, voluntarily along with the child. Then, my lord, she filed a petition before, my lord, Udupi court for domestic violence, where, my lords, she has awarded with 10,000 rupees. My lords, it is an interim maintenance. The proceeding is still pending. I have been prosecuting this case, my lords. In addition to that, the 10,000, my lords, another 30,000 is awarded.
So you are paying how much now, as of now?
My lord, I will pay, my lords, 15,000 for.
Not from this. You said about the other proceedings.
Please. Other proceedings, my lords, 10,000 I have been paying, my lords.
You're regular in paying?
My lord, last 1 year I have not paid, my lords, because after collecting my amount, my lord, she filed another petition before the family court at Mangalore. But that is the problem I am facing. She made me to wander here and there, my lords. So first, my lord, she files
Pay
the petition.
15,000 in this.
Please, my lords.
Pay 15,000.
Please, my lords. I will pay 15,000, my lords, with the arrears, my lords, within.
15,000.
Please.
Arrears will come to how much?
But arrears would be, my lords, 4,85,000, my lords.
When will you pay?
Lord, 33 months, my lords, from the date of petition.
When will you pay?
Lord, 4 weeks, my lords, for about 2,50,000, and remaining balance, my lords, another 4 weeks, my lords. Because I have to pay, my lord, 70,000 for housing loan as well as.
You have already calculated at 15,000.
Yeah.
If the agreed with the orders passed in criminal miscellaneous number 7 of 2022, dated 1st July 2024, the husband is before this court. Land council submits that the court had granted maintenance of an amount of rupees 10,000 to the wife and 20,000 to the daughter. In the other proceedings, what are those proceedings?
My lord, proceeding, my lord, so that is criminal miscellaneous 130/2020 at Udupi court, my lord, for domestic violence.
In the proceedings arising out of the domestic violence, court is already there granted 10,000, and thereafter the present application is filed by the wife. It is submitted that that the salary of the husband is 1 lakh and 75,000 is paying towards the EMI, which has taken, which loan he has taken during the subsistence of the marriage. It is submitted that having obtained an order in a domestic violence case, again, the present petition is filed seeking maintenance. Now this 30,000 and in that another 10,000 is made to pay 40,000 to the wife and the child, considering the submission of the land council for the petition. They shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 15,000 by 5th of every succeeding month. And the arrears, for how many months?
Not 33 months, not from 13th January 2022.
At 15,000, 4,85,000. He shall pay deposit 2,50,000 within 4 weeks from today. And remaining amount from 4 weeks from there on. If the petitioner fails to pay 15,000 or the first installment for the first amount after 4 weeks or the second one, the stay granted by this court stands vacated automatically. But is notice to the respondents.
Obliged.
Yes, next. Yes.
Till number 35. I'm appearing for appellant fellows. Total 16 hour engage ಆಗಿದ್ದಾರೆ tomorrow.
Give the docket, the order sheet. In the morning section, you requested for a passover and no representation on behalf of both the parties in the afternoon. Post this matter on the caption for dismissal. At the request of land counsel, the appellant post this matter on 26/8 and again on your request. How many days it will go on? So what is to be done now if he's in 16th court? So that you will not come next time when the passover is called. We'll keep it, let your senior come, or else we'll dismiss it at the end of the list. Yes.
Cell number 36, Abhinay YT, for appellant, KG, Chanswaj.
My lords, appearing for the appellant,
For the appellant, my lords.
appearing for the appellant, your lordships. My lords, what had happened in this matter, my lord, I humbly apologize for not appearing on the last date. Counsel for the appellant, my lord, had resigned from this matter. Only recently, my lord, I was given the file.
So you have filed your wakalat or not?
My lords, I'm filing it today, my lords.
Lords.
I received the necessary signatures from the party. I'll file it today, my lords.
Lords, the name of the council, Abhinay YT, his name may be taken off from the list. He would be up here.
Delete the name of Mr. Abhinav. What is your name?
My lords, Vaibhav Malimat, my lords.
Write on a paper and give.
I am for Abhinay YT.
Huh?
I am for Abhinay YT.
What?
Name, sir?
Vaibhav M.
Delete the name of Mr. So-and-so and it is submitted that Mr. So-and-so has instructions to file wakalat. This is directed to print his name, will delete from the caption dismissal post after vacation.
Grateful, my lords.
Cell number 37,
Next on 4th of November.
I appear for the petitioner in this case, your lordship. On the last date of hearing, your lordship heard the matter and directed me, my lordship, whether the respondent is willing to join the petitioner. I inquired with the petitioner. My lordship, petitioner is ready, but the respondent is not willing to join with the petitioner.
Where is the counsel for the respondent?
So the respondent counsel informed me that my lordship has issued NOC today.
Yes?
He has given NOC, my lordship, to the respondent.
Hello, I'm the respondent of in this case, ma'am. My phone has hacked, ma'am, my lord, and they access a micro camera and microphone. They're avoiding my lawyer to not to do the case in my favor, and they are listening my voice and everything. They made nude videos of my child, also 17 years old, ma'am.
Oh.
My lord, and they are avoiding.
You have to engage an advocate or else you have to do.
I need a time, my lord.
Respondent seeks time to engage an advocate. Pose this matter on 11th of November.
Yes.
Next.
hearing on intercustody applications, cell number 38. MB Inamdar, Parliament, CGC.
Your Honor, I am for the respondent. I am for the appellant. In
We'll
this
condone the
case-
deal. Where is this IA 2 of 24 for recalling the judgment? What is the judgment?
Dismissed for non-prosecution.
Huh?
It was dismissed for non-prosecution.
But to recall that order. When is it dismissed for non-prosecution?
So
When is this application filed? And what are the reasons for not appearing before the court? Open that order. What do you say?
My lord, on 2/1.
Who appears for the respondent?
I appear for the respondent.
What do you say?
We consider.
I number 1 of 24 is filed to condone the delay of the delay of 16 days in filing the recall application. And I number 2 of 24 is filed. recall the order dated 10/1/2024. On 10/1/2024, this court had dismissed the appeal for non-prosecution on the ground as there was no representation on behalf of the appellant. Now the IA is filed stating that as advocate on his personal work was out of town, the matter was not represented, and the said absence is neither willful nor wanton. Considering the same, and the reasons stated, IA 1/24 is allowed, condoning the delay of 16 days in filing the recall application, and consequently, I number 2/24 is allowed, and the appeal is restored to file. Was this matter for, it's coming up for final hearing.
Final hearing.
Post for final hearing after vacation on November 12th.
Obliged.
Till number 39. Kuladi.
And for the appellant in this case, my lord. In this case, suit for declaration, my lord. Declare the termination of membership, my lord. The party in person has filed the application under section 39 rule 1 and 2 for seeking to continue the membership, my lord. The same has not considered and reject the.
Who appears for the respondent?
Please, my lord.
Respondent AC Nanjareddy. Yesterday was there.
Was anybody appearing for the respondents? None appears, relist this matter on request relist. Yes, let's see what is the order.
My lord, order is that, my lord. That is in page number 29, my lord. The higher has been rejected by the trial court, my lord.
What is the suit for?
Suit for declaration, my lord. That for declaration, declare the termination of membership, my lord.
Let's see the plain.
Please, my lord. Kindly see the page number 28. That is the order, my lord. That is the order has been challenged, my lord. Sorry, 56.
Come to the plaint. Plaint.
Plain, please, my lord. Prior, my lord. That is in page number 82. 81 from the 81, my lord. And 82. To pass the judgment and decree to declare that the board resolution passed in termination of membership of plaintiff dated 28/1/2020 by the defendants herewith produced and marked as document 28, my lord. That is illegal and arbitrary. That is the prior, my lord. And the appellant has filed on 39 rule 1 and 2 application. That is in page number, my lord, please. Page number 120, my lord. 120 is the applications. In page number, that for the reasons sworn to in the accompanying affidavit, the plaintiff most respectfully prays that this honorable court be pleased to grant an interim order of temporary injunction against defendant to stay the operation of resolution. Order dated 28/1/2020, passed by the defendants. And herewith produced the document marked as document number 28, and not to disturb the membership of the plaintiff, my lord. With the first defendant, my lord. The same has been dismissed, my lord. The ground that, my lord, in page number 44 of the order,
That is in page number 43 of the impugned order, madam. Please, shall I read?
Yes.
Please, 43 in page number, para number 10, my lord.
Read from para
Please,
8.
my lord, sorry.
Read from para 8.
Please. I have perused the relief sought in the plaintiff. Plaintiff has filed a suit for the relief of declaration to declare that board resolution passed in termination of membership of the plaintiff dated 28/1/2020 by the defendant is illegal and consequently has prayed to declare that the plaintiff continued to be in the member of the first defendant and is entitled for the benefits and privileges provided to valid member. To continue the membership of the plaintiff, with the first defendant, mandatory injunction directing the defendants to give replies to the submissions made by the plaintiff with the supporting documentary evidence. Mandatory injunction directing the defendant's office bear and directors to compensate monetary loss incurred by the plaintiff. Have perused the relief sought by the plaintiff in is HIA number 1 filed under 39 Rule 1 and 2 of CPC, wherein he has sought for temporary injunction against the defendant to stay the operation of resolution dated 28/1/2020 and not to disturb the membership of the plaintiff with first defendant. Though the relief sought as a prohibitory temporary injunction, it appears to be the nature of mandatory injunction. In order to get such relief, the plaintiff has to prove his relief of declaration. Hence, in my opinion, at this stage of the case, temporary injunction cannot be granted as sought in HIA number 1, my lord. My lord, as per resolution, my lord, kindly see the page number. The order of the resolution passed by the respondent, my lord, please for a minute, my lord. That is in page number 56, my lord.
Yes.
That is the resolution order, my lord. In this, my lord, subject intimation of board resolution regarding termination of your membership. Yes, Naresh Kumar M. number so and so from Andhra Devanga Sangam. Please, here, Malla, reference, there is no departmental inquiry, nor a charge sheet, nor a show cause notice, nothing, Malla.
What departmental inquiry?
From removing the membership, Malla, they must have to conduct the departmental inquiry. He has to produce a charge sheet. Charge sheet has to be proved. They are clearly stated that, Malla, in this para, please note that we served that the board
Member of an association.
Please,
What is the departmental inquiry in that?
They are stating allegation.
There is a procedure again. No, some resolution is passed. Against that, there is a provision for of appeal within 30 days. Why have we not availed it? Why he has not availed that?
Appeal.
Before the general body, there is a right of appeal within 30 days from that order.
He has filed not.
He has not filed, that is the observation of the court. Where is that he has filed? You appear?
I appear for the respondent 2 and 3, madam.
Mm.
Today morning I filed power.
Yes.
He has not filed that statutory appeal. There is a provision under the bylaw.
That is pending.
Any person aggrieved by an order of termination, he can file an appeal before the next general body within 30 days from such an order. That he has not availed. That is the observation made by the trial court. While
But
rejecting the appeal.
he's stating that he has filed that appeal.
There is no whisper, my lord. The trial court has not rightly absorbed.
Moreover,
There is
my
no
lord,
whisper.
He has given a complaint to the deputy registrar, but he has not filed an appeal
In
as
respect of the
contemplated.
respondents, my lord. Respect of respondents, he has given a complaint against that respondents, my lord. The members of the Devanga Sangha only.
Show him where did he file an appeal.
Appeal proceed. Statutory appeal, deputy registrar appeal, not remain.
In page number, my lord, 15, in page number 15 of the impugned order. The trial court, my lord, has observed there is no pleadings with regard to the fact whether he had approached the annual general meeting within 30 days in order to comply with such provision under memorandum of association rules and regulations. Running page number 43 in page number.
Okay, ಅದನ್ನೇ ಕೇಳ್ತಿರೋದು. Field provision, other kind. Then
Please come.
please.
The trial court had rejected the application of the petitioner to grant of injunction. Observing that, as per the bylaws, he has to approach the annual general body. No, what is the annual general meeting?
Annual general meeting now, it comprises of all the members, all primary members of the association. It's a meeting of all the.
He has to file an appeal before the general body.
One submission, my lord. They have stated that the primary membership against those illegal acts on the basis of those correspondence.
General body meeting.
Yes.
He has to
Exchanged
appeal
and-
within 30 days. Instead of doing it, he has made complaint to the deputy registrar of cooperative society. He has failed to avail the statutory remedy available to him. The court had, and the other things has to be decided in the due course, and dismiss this application. Land council submits that, yes, or the land council submits that as per our instructions. The petition, the appellant has already filed an appeal for the general body, which is not forthcoming from any of the material. Post this matter after vacation on November 12th. By
Liberty
the
may be
time,
given to
if
file the
any,
appeal.
if any necessary, if any documents are there, they shall be filed before the court with an appropriate application. Yes.
Till number 40, adjourned 41. Pawan Chandra Shetty.
Yes.
Notice has to be.
My lord, there is a delay in 808 days, my lord, in filing.
Notice to the respondents.
Till number 42.
Appellant is permitted to take out notice on the council appearing before the trial court and shall file a memo to that effect by 14th of October, post this matter on 22nd October. Yes.
Till number 42.
Pen for respondents, Your Honor. I'm for the petitioner, my lord. There is 298 delay in filing the present petition, my lord.
Lords, the conduct is such that they are,
You file your objections.
no, I have, it may be allowed by lord, but only
Yes.
on.
IA number 1 of 23 is filed to condone the delay of 299 days in filing the petition. Where is your affidavit?
Para number 6 I have discussed, my in affidavit, my lord. Page 28, my lord.
Hmm?
Page number 28, my lord. Page number 28, my lord. In affidavit.
Affidavit here for the delay.
Yeah, my lord.
What did you say? What is the reason for this delay?
No, my lord, they have got export order, my lord. Before that, my lord, they have filed in the year 2022 petition, my lord. Before that, in the year 2021, I have changed my address and I have produced the document also, my lord. Changing of my address. But they have mentioned my previous address and they sent notice to that address, my lord. Good certificate and aware of.
It's an ex parte order.
Yes, my lord. But petitioner is paying.
Stated that.
In para number 6, I have discussed.
That's up until to warrant was issued, they have not come to this.
Uh-huh.
Up until warrant was issued in the execution petition, in the criminal miscellaneous 357 of 23.
Hmm?
In the criminal miscellaneous 357 of 23, we have filed for execution of the criminal miscellaneous 110/22. So after a warrant has been issued, they have come running to this court for this relief. Only the conduct may be.
In view of the, as the petitioner is not aware of the pending criminal miscellaneous number 110 of 2022. As a notice was not served on him and he could not contest the matter. As such an ex parte order is passed. It is the case that the respondent herein has furnished an address in which the petitioner earlier used to stay. In view of that, he could not contest the matter. And once they came to know about the warrants, once warrants were issued by the court. NBWs were issued at that point of time. He has come to know about the order passed by the court. Then has applied for the certified copies on 1/7/2023. And he got the same on 7/7/2023. And immediately he has filed the present petition. It is submitted that the said delay is for the reasons stated, but it is neither willful nor wanton, considering the reasons stated in the affidavit accompanying the IA. The delay is before that, no objections are filed by the respondents, considering the reasons stated in the accompanying affidavit. The delay is condoned. And to delay in filing the petition is condoned post this matter for preliminary hearing. Yes, next.
43.
By
Megana Mudurangappa for the petitioners on.
the respondent.
Ramesh Kumar. My lords, there's.
Condoned.
Yes.
I number 1 of 24 is filed to condone the delay of 90 days in filing the appeal. For the reasons stated, delay is condoned. Post this matter for admission.
Cell number 44. Victor Manoharan S.
It's 248 days delays.
Okay, sir.
248 or 1248?
248 plus 1.
The notice to respondents, yes.
Cell number 45. VK Sampath Kumar. Purnima for respondent.
My lord, the first petition is filed by the wife, my lords, insofar as we had filed a section 24 application, my lords, a sum of 15,000 was granted, my lords. I've sought for enhancement. The same order, there's been challenged by them later subsequently, my lords, where they've sought for reducing that said
This
amount.
matter 45 and 45.1 on Wednesday. Yes, next.
The interim order may kindly be accepted.
Interim order earlier granted is extended in them. Yes, next.
Cell number 46.
May be allotted.
Wednesday.
25.
May I also
Tell them
pass
about-
on one memo, my lords, I've just served my learned friend.
File it.
Please, my lord.
Yes.
Cell number 46. P. Nehru. For
Very well, petitioner, my lord.
Prabhu Gaur Tumgi.
My lord, the respondent had filed an application under section 340 of CRPC stating that she has given false information and pray this honorable to take action after inquiry.
You
I am
filed your
filing-
objection?
I am filing objections, my lord.
Not here. File it in the section. Have you served on him?
He is not there. Already I will serve. I will file in the office.
Counsel for the petition is present. No representation for the respondent. Close this matter after vacation on 21st of October.
I will file in the office, my objection. Much obliged.
47. Vardhaman V. Gunjan. Ashish R. Agarwal 40.
Your Honor, I filed my, on day before yesterday, Your Honor, I was asked to file before the Honorable Court that by when will I be able to make the DD ready. Today I filed it in the filing counter, Your Honor. This is my office copy for your kind reference, Your Honor. It is by the end of October, I will be able to
Pay the money. Where are
yes.
they?
Your Honor, I've just met Advocate Vardhaman V. Gunjal outside the court. He has received the copy also. His copy, his signatures are duly there on the.
I'll call the next matter. Just look at it. You will find him again in the corridor. Call him. Pass over. Yes. No, finally not to call. This pass over this matter.
Ma'am, my copy. may I
It
take-
will be there. You can come back. Yes, pass over.
Passovers matters. Cell number 8.
Yes. Yes.
My lords, I have objections to this. I have to file my objections. Unfortunately, I not know about the matter today, but I have objections to this. I may be permitted to file the objections. The
Oh, the
court,
court, just because he's asking every day, court will grant straight away overnight custody.
my lords, overnight
What we will do is, this order for some time, we'll modify this order. He can take for those 2 days wherever that overnight custody they've said. Let him pick up at 10 o'clock in the morning and again drop him back in the evening.
evening 6 o'clock.
Huh. That will be, we'll see for some days. Then later we can,
So on
what
Saturday,
is to be done. then
Saturday
we
and
can-
Sunday, both days,
Huh.
10 o'clock.
Whatever that is granted by the trial court, on those days, he will take him and send him, again, drop him back at 6 o'clock.
Saturday and Sunday, both days, 10 o'clock to 6 o'clock.
Second week and fourth.
Huh?
Second Saturday and fourth Saturday.
Like how it is, how it is
However
ordered
it
by
is,
the.
yes, that way,
Same.
My
yes.
submission, man, let him come and pick up the child wherever the last time your lordship has ordered in the park. There only she'll come and hand over the child, and let him come and hand over the child there itself. And your lordship has, last time your lordship, while passing the orders, has directed him to pay 10,000 rupees per month. That amount he has not paid.
my lords, he will, right now, he's facing some financial difficulties, he doesn't have a job. He's paying some partial amounts. He ensures that he will pay the full amount. Whatever is there, he will make payment. Sorry. My lords, he'll make the payments, my lords. He's made partial.
Very
payments. He's
simple,
made
Lord.
5,000.
The accused order is at page number 21, my lord. Relevant portion is that from page number 24 it starts. Because on 3 years the orders has been passed.
The agreed with orders passed in I number 8 in GNWC number 1481 of 23.
7, my lords.
7, A number 7.
7, IA number 7.
So I number 7 in GNWC number 148 of 23, dated
Dated
4 September.
4/4.
4 September. 4 9.
4
9.
4/9.
4/9/2024. The mother is before this court. The father has moved an application seeking a direction to the, seeking a relief to see the boy, to have the visitation of the boy every day. In that, the court has passed an order giving interim custody of the minor son 2 days, for 2 days, twice in a month. That is on every first Saturday and Sunday, and on third Saturday and Sunday. The respondent the father is permitted to pick up the child on or after 10 a.m. on every first and third Saturday from the residence of the mother and drop the child back. That is what is given by the court also.
No, it's after the overnight.
Saturday morning, so from Saturday morning to Sunday evening.
Oh, Sunday, 6 o'clock, before 6 p.m. on the respective Sundays, entrusting the custody back to the mother. The mother is directed to cooperate with the same, agreed thereby. The father is before this court, the mother is before this court, and counsel submits that the boy is aged 3 years, and straight away, the court, without any reasons, just because he has asked for a daily custody, the court cannot pass such an order and grant overnight custody of the boy, aged 3 years. The court at least ought to have taken into consideration the age of the boy. Then counsel appearing for the father submits that the boy is comfortable with the father and the grandparents. Considering the same, the court has passed an order. Next para. Considering the rival submissions of both the parties, this court is passing the following order. 1, the father can pick up the child on first Saturday and the Sunday at 10 o'clock from the park, which is near to the house of both the parents, and drop the child back by 6 o'clock at the same place. And on third Saturday and Sunday also, the same arrangement shall continue. Earlier this court, next number 2, earlier this court has passed an order wherein the court has also observed that the father shall pay an amount of rupees 10,000 to the child towards maintenance. It appears that the father is not paying. Land council submits that the father will be paying the amount. Next 3, pose this matter, but basing on how this works, how this arrangement goes, further orders will be passed. Pose this matter on 16th of October.
And
He's
submission,
making
my lord.
partial payments, my lords. It's not that he's not making any payments, he's making 5,000 rupees.
Yes.
Saying financial.
While feeding the child, let him be.
No,
little
no, one more
cautious.
thing. the mother shall furnish the details of the allergies or whatever it is, which are the foods not suitable to the boy, and the father shall adhere to that.
Cell number 11. Cell number 11.
Appear for the petition.
Respondent.
Harshvardhan. Shobha.
Land. Commitment.
I filed the affidavit.
What is
yesterday.
the affidavit you have filed?
Your Lordship, there were a few questions which were needed to be answered. So, first one was, we tried to show some statements where,
Regarding the bank transactions.
the bank transaction and the, for that explanation you wanted, and the relationship means, he has two beauty parlors.
Please tell the facts, I don't remember. What are the facts? Yes,
My lord, actually, in fact, the respondent is running two beauty parlors, my lord, along with his girlfriend.
you are for the wife.
Yeah, I am for the wife. my
What
lord.
is the amount granted by the trial court?
Amount granted by the trial court is 30,000 per month, my lord.
30,000 per month.
30,000 per
How
month.
much you sought for?
We sought for 50,000 per month.
According to you, what is his income?
He actually was working in a tall tech company and was earning more than 2 lakh rupees per month.
Anything
And-
on record?
Yes, my lord. It,
Was it placed before the trial court?
yes, my lord. It was.
About his income of 2 lakhs?
Yes, my lord. I have,
Your Lordship.
I had produced the bank statement of.
Please
the
come to that
respondent.
order. Please come to the order.
He was being placed ex parte one.
Hmm?
He was placed ex parte for the assets and liabilities, this one. The interim order was ordered before issuing a notice to me, Your Lordship. See, without giving me an opportunity.
Part order.
Yeah,
My lord,
yes,
even if
interim
the
order was taken by ex parte.
Let's see the order first. Where is
Yes,
the
sir.
page number?
Kindly,
I'm looking at
page-
WP double triple 37.
3337.
Page
Yes, sir.
number, where is the
Page
order?
number 119, my lord. This is the operating portion of the order, my lord. The respondent is directed to pay a sum of rupees 30,000 per month towards interim maintenance. And it further says that observation made by the trial court is in the paragraph 3, my lord. To the support of IA number 2, the petitioner Kavita has shown to the affidavit stating that he has filed the petition before a decree of divorce and she has no source of income. The
No, this is an
respondent,
ex parte order.
yes, my lord, but I have produced enough evidence to prove.
Why
that
not? Why not the
court is
court give
income.
notice to them and do it?
Actually, I had produced the bank statements of the respondent in which he was
Let the
getting
court
the
decide,
salary.
let the trial court decide this.
My lord, one more thing.
Yes.
Today they have filed the affidavit.
All that
My lord,
filed before
one-
the trial court. Now the court will not look
my
into
lord,
all
one
that.
submission. They have stated that I have misused the amount while looking after the parlor. Actually, they are stating that petitioner was looking after
Agreed
the
with the
parlor.
orders passed.
Just 1 minute, ma'am.
I number 2.
There's just one submission. They have misleading the trial, misleading this honorable court by
No,
filing this.
court is not getting misled by them. I'm not looking at it. So don't worry. Agreed with the orders passed in I number 2 in MC number 6357 of 2021. Dated 12/1/2002. The wife is before this court. The wife had filed an IA seeking maintenance of an amount of rupees 50,000 per month and litigation expenses of rupees 30,000. Basing on what the wife had stated, the court had granted an amount of rupees 30,000 per month, which is an ex parte order. Agreed with the seeking enhancement of the maintenance. Wife had filed WP number 3337 of 2024 and questioning the maintenance granted. Wife had filed, husband had filed WP number 8083 of 2023. they have filed before this court, the statement, the bank statements and other particulars. According to the case of it is the case of the husband that he is not in a position to pay the said amount granted by the court. And the court ought to have given an opportunity to the husband. And then should have passed an order of maintenance. Then counsel appearing for the wife submits that the wife had placed sufficient material before the trial court, and the trial court considering the same had granted the maintenance. Looking at the material placed by him, having got the counsels on either side, there is a material on record. The court had granted an amount of rupees 30,000. It is 30,000 towards interim maintenance without even hearing the respondent, without even giving an opportunity to the husband to put forth his case. In the light of the law laid down by Honorable Apex Court in Rashish versus Neha, had an opportunity being given to the husband, he would have filed his statement of assets and liabilities. The court if in the circumstances, even if it feels that an ex parte order is required, it cannot be at an amount of rupees 30,000. Considering all this court is disposing of the matter.
My lord, one submission. I may be permitted to file my rejoinder. Actually,
that will
in
not.
this case, madam, kindly have it on 24th.
No. That
one humble submission. They are misleading the court by their affidavit, and
that
I
affidavit
can
and all,
establish that
please
they are misleading the court.
understand all that the court, before the court below, you do it. What is the purpose of filing the things before the court when the court is not considering their affidavit? Let them file whatever they want, but the court is not considering. You file whatever you want before the trial court.
But my lord, they have not filed even a single document along with.
I will direct them to file. For that, whatever you want to file, file accordingly. This court is passing the following order. One, both the order dated so and so is set aside and the matter is remanded to the trial court. Both the husband and wife, as per the law laid down by the Apex Court in so and so, shall file their respective statements of assets and liabilities within a period of one month from the date of receipt of the copy of the order. And within 1 month within 2 months from thereon, the court shall pass appropriate orders.
Madam, he has not paid the arrears, madam. There is an arrears of 7 lakh, nearly 7 lakh. From the past 3 years, he has not paid the arrears.
Lordship, that's a wrong submission. what
He is
making.
working, he is earning more than 10 lakh rupees and
19
he is not paying the arrears.
Yes.
Your Lordship, on 19/3, you only have ordered that there is an
And in
arrears
the
of 3 lakhs.
entire
sir,
three
none of this
petitions,
I have money.
he has not stated even his income also, my lord, in the entire 3 petitions. Even
For
before this,
19/3, you have
honorable court, he has
ordered
not
The
stated his
petitions are
income.
disposed of.
Your Lordship, on 19/3, you have told there is.
What is this 11.2? There are like 11.1 is
One-
what is
Your Lordship,
11.2?
one writ petition I had filed because he had taken, for an interim order, he had taken arrest warrant against me. Execution 130.
WP number 28807 of
8083.
2023 arises out of the execution proceedings. Yes.
That is an
8083 is against the execution proceeding.
execution, Your Lordship.
28807.
8083 is against the execution.
Is an
proceedings.
interim,
Yes, WP 28807 of
that is for
2023
interim maintenance.
is against
stays, Your
questioning the
Lordship.
1 minute. He's seeking enhancement of maintenance. Yes.
Cell number 15.
He has submitted completely false. I can establish if court.
Can
permits it to
establish
come.
before the trial court.
Within 2 seconds, my lord, I can.
Now,
I have
what
produced
the
the
trial
court.
court is supposed to do, all that exercise you are making the high court to do, looking at all the bank statements, how then the
I will
court can do all that?
produce it
And
in
that
a
way it is an ex
summary.
parte order. First of
Summary.
all, you should have not come before this court. It is an ex parte order. Already court has given you a big benefit by granting 30,000 without even listening, hearing the other side. Yes,
But
next.
he has
15. Sanjay Nayak. Petitioner Guppy S. Supparao.
My lords,
Yes.
appearing for the petitioner.
When
The
is the
petitioner is
petition?
ready to appear before mediation center on Monday. my
When?
lords. Monday, my lords.
Monday means on 30th, on
Yes,
23rd.
my, yes, my lords.
Both the parties.
Your Lordship, but one thing, this court directed them to produce the Aadhaar card. They've on purpose produced half of it.
Both the council submits that there is a scope for mediation. Parties are directed to appear before the Bangalore Mediation Center on 23rd at 3 p.m. The registrar judicial is directed to communicate the same. Yes, next.
Please.
Cell number 17. Cell number 17.
We respond.
You saw that?
Please, my lord.
Oh.
Colleague has already.
Give that.
Whatever.
IA, that IA is ordered, I mean called for.
Yes.
Yes, no, they appear. No. IA number. IA one of 2024 is, 2021 is filed to bring the LRs of R5,
Yes, ma'am. Please.
to bring the LRs of R5 on, the notice is ordered by this court. And so has filed wakalat on behalf of the LRs. Accordingly, IA is ordered and the petition shall carry out the necessary amendment to the cost title. Yes,
Week it may. Next.
Twen-
Next week it may.
what is this? Which year is this?
After vacation.
Yes, after vacation will come. Post after vacation on 21st of 24th of October. Yes.
Oblige.
Cell number 23. Cell number 23.
Yes.
For the, all these matters are already by lordship. Bulk arguments for a while.
1 minute, we'll continue with your matters because it will take long time. One passover is there, I'll just finish it and we'll continue with this. Yes,
24. Cell number 24. Ramesh Kumar.
yes.
Milord, in this case, Milord,
Who's appearing for the respondents?
N. Krishna.
Milord, respondents, Milord, were served through, they had entered caveat. Copy was served. Milord, despite service of.
They
Milord,
never appear.
Never appear. And so.
So
far,
respondents are served.
served. Other respondents.
On all, on behalf of
Only
all the
plaintiff-
respond,
Milord, only plaintiff is the contesting party.
for that caveat is filed.
For that caveat. is filed.
For the other respondents, you
Other
sought for
respondents, we have
dispensation?
filed memo seeking dispensation
Yes.
of.
Yes.
Milord, the appellant is challenging, Milord, the order passed by the trial court on IA number 28. Milord, the suit was filed in the year 2010. Milord, IA number 10, IA number 28 was filed subsequently, Milord, after lapse of
So
30
the
years.
difficulty is again, they will come and ask for a recall of order. What we will do is, today I'll record that there is no representation on their behalf and post this matter tomorrow on the top of the list
Please.
and then dispose of.
Please.
Otherwise,
Please.
the caveat is filed on behalf of the respondent plaintiff and land counsel submits that they have already served the papers. Their name is also reflected in the cost list. As far as other respondents are concerned, he sought for a dispense with, and the same is notice to them is dispensed with. No representation for the caveator. Post this, heard the counsel for the appellant in part. Post on the top of the list tomorrow.
Please. Much.
Yes, next.
Cell number 23.
20?
3.
No, there is one more passover, no? That party in person passover.
Cell number 30.
Where is she?
Cell number 35 is party in person.
Submission regarding serial number 711. Actually, is whole transactions with the parlor is between the 2018 to 2021. If now, as per the order of this Honorable Court, he will file the statements before from the 2021 to 2024 manner. Actually, he may kindly be directed to file the bank statements from 2019 manner.
When was the, it is as per strictly as per Rajneesh and Neha. When the petition is filed, how it has to be filed. Accordingly, let the,
from
we
the
don't
date
have
of
to
the-
tell them. As per Rajneesh versus Neha, as on the date of filing of the application before 1 year or something is, accordingly, they have to file. Yes,
Cell number 35, one more matter passed over, ma'am.
yes, yes.
Om Shekhar KM.
35.
Cell number 35.
Huh?
You are clear.
Who was this matter after vacation on November 4th? No time for the court now. Yes,
For 20.
14%.
14%.
Yes.
Your Honor, I have filed my side of,
My lord, what has happened is,
Hmm.
on day before yesterday, the memo that we had given was accepted by the court. Only two things were expected from us. One is regarding the lump sum payment amount. And secondly, with regard to when we can go to Mumbai for closing the accounts.
Correct.
Now, entirely new draft has been filed again, my lord.
Your Honor, it's not a new draft, Your Honor. It's on record. It's, Your Honor, all the contention.
Why the matter is adjourned on the other day? Two things. One is when they will be going to Bombay to
Yes.
operate that account, number one.
Yes.
Number two is when will you pay the money?
Yes, sir.
Apart from those two, why should you again, start a new story?
It's not a new
Now
story, Your
again-
Honor. Your Honor, may kindly.
Please
first
look at the order.
Because again, if we go clause by clause, there are some things that are inserted.
Was this matter on 29/2024, and by the time learned counsel, the petitioner wife shall get instructions regarding which day is convenient for her to open the locker jointly, and the respondent party in person shall also submit to the court when he will be ready with the money. That's the only thing the court asked. Every time court has no time to, hear you and start a fresh and a new story.
Your Honor, there is,
What is that affidavit? Give that affidavit.
Another memo is.
Affidavit, where is that affidavit he has given? This one he has given, no. This office copy. Yes, what is he saying now?
Now, I had filed a memo on 18th, my lord,
Gita.
wherein my lords were also pleased to. go
What he says now, please come to that.
Your Honor, there were 2 points, but the third was that in their memo, the point number 2B1 and 2B2 was supposed to be clubbed on a context that the amount may be made a lump sum amount, clubbing the two amounts, 2 points which they have mentioned in point number 2,
Correct.
B1 and
Correct.
B2, Your Honor.
No, you don't have to file all this. That the court will take care at the time of passing the final order. You don't have to unnecessarily again extend
it
this
was just-
litigation now. Simple. You are ready to pay.
By the end of.
We'll not take your memo. All this, let's not take anything on record. No, the court will record that by which
End
date
of
you said?
October.
Huh?
End of October. yes.
By end of October, you'll pay the entire amount. And that time we will post this matter. And in the meantime, what is to be done is those locker to be opened.
I've communicated with them. They'll need to confirm a little bit with the school dates as to daughter school dates. They said they can confirm by tomorrow morning.
To confirm it also, she requests this much time.
No, only because of
No,
the
but she has to
daughter.
understand, he has to come from Bombay every time.
Yesterday also, I
They
just
can go
reached Mumbai at 4 in the evening. I have,
Why did you come?
Open the locker.
Your Honor, I was not able to log in other OTP. There are 2 OTPs in the registration. One is the mobile OTP and one is the email OTP. At 5:45, I have contacted the VC branch, Your Honor, on the top floor on 2 numbers. They assisted me, but the server was down, and in the midnight, I have booked a flight ticket and I have come today morning, Your Honor.
Anyway,
What's the
responded.
simple reason you're asking adjournment? And
Uh,
what is, where is your client's intention to put an end to all this?
No, she is ready to go, my lord. Only thing
Oh,
is with
like,
respect to date.
she doesn't have the calendar of the girl.
Whatever, my lord, yesterday evening he called me and said he is not coming. Then we prepared as such. And again at 11 o'clock when I was arguing a matter, he sent a message, he sent a call that he is coming. At 3 o'clock, he was giving me another joint memo. I took it. I was in another court, I took it. No, my lord, he takes everybody for granted. If your lordship fix the date, we should go to Bombay and open the locker, we are ready. But one thing, my lord, he has individually operated the locker already many times as per his own records.
If-
I am ready for that also.
My lord,
Your Honor,
If
Your
I
lordship may
research-
direct
you are
us
not
to go to
interested for
Bombay.
any,
We'll go to Bombay and open the locker.
when is that?
We'll go.
As per the direction of the court, my lord, we are ready to oblige, my lord. He is anyway.
Your Honor, my humble submission in this was only in the today's memo, Your Honor, it was only that in a locker, the bank personnel is not allowed to go inside the locker premises. For an extent, they just have to place the key. For that extent, they are going inside the bank personnel goes inside the locker room, Your Honor, the strong room. My humble submission before this honorable court was the petitioner intends to operate the locker, even though she has individually on the 6th, when there are 5 adults who had come there, maybe to part the jewelry, because there are 5 people who have come just to receive her from Mumbai, which has never happened in the complete matrimonial span of 1 year.
What are you submitting now?
So, Your Honor, my only submission was that when the petitioner operates the locker, I also would be present
We have
as,
mentioned it, my lord,
and
both people
the
will operate it.
some bank personnel may be directed to be there with both the parties in the locker room, Your Honor, because there I am, Your Honor, such submissions which they make before the family court also, Your Honor. In the past, I have been.
Please understand, court will not continuously monitor what is happening in your lives. Understand?
Your Honor, but there are
If you
chances
don't
that they
want-
might.
Both of you have those kind of trust issues, then let this
Honor, my
matrimonial
only
proceedings
submission-
go on for next 10 years and enjoy that. You keep traveling from Mumbai.
Your Honor, I want to, I'm just afraid of any malicious things they do. Your Honor, if a bank personnel is just instructed to be there in the operation, I just want to be there to see whether what
Close
my.
this matter after vacation. Post on 11th of November. You people are not understanding how much the time court is spending and how the court is trying to give you a relief. And without that, one after the other, she doesn't have time to say when she will go to Bombay. You will, when the court asks you only to say when you will pay the amount, you
Apologize,
will
Your-
come up with 101 doubts. You clarify your doubts and let the whole process take its own time. Then you will understand how it is.
My lord, I
Pose this
personally-
matter on November 19th.
my
Yes,
lord, I
next matter.
personally give an undertaking.
Your,
If
Your Honor,
anything fixed by the
Your
court,
Honor,
I
I
will
have
raise
my
it.
LLB second year exams on 18th of November. Any date between,
Pose this matter in December.
Your Honor, before, Your Honor, I'll have to
My lord,
make
I
a
will-
KT
You
for
write your
that.
exams and come back.
Your Honor,
December 16th.
Your Honor, 16th of,
16th.
1 day
December
prior, Your Honor, I just need.
December 15th. Yes, next.
December.
No, Your Honor, in the month of November, Your Honor.
No. Pose this matter in December. Next matter. Call that password matter.
Parted, my lord. It's parted, my.
No, part heard. Delete from the caption part heard.
Serial number
Yes.
23.
I appear for the respondent.
Yes.
But I submitted that, my lord, on 12th August 19,
Yes.
2024. Your lordship was pleased to hear the matter for a while. There are 2 suits, my lord, out of which, my lord, these proceedings arise. This is a common order made by the trial court, but dealing with, my lord, IS 1 and 2, filed in OS number 39. Your lordship has made notes, my lord.
Yes, that's what I'm looking at. Please tell the court. What is that?
398 of 2022.
Hmm.
This is a suit filed by the respondents herein.
Hmm.
That is,
This is defendant's appeal.
this defendant's appeal.
Hmm.
There, there they have filed, my lord, the applications, interlocutory applications 1 and 2, seeking temporary injunction against night.
That is 2069 is temporary injunction. 2051 is MFA 2051 is IA
Sir.
number 1.
Two IAs were filed.
One is
One is for restraining my clients from interfering with the administration of the trust.
that is IA number
1.
2.
IA number 1.
I number 2.
IA number
IA
2.
number
That
2.
is temporary injunction.
IA number 2.
Then IA number 1 is
IA number 1 is, my lord, for restraining us from operating the bank accounts.
From
These
operating
are
the
the two
bank account, yes.
interlocal applications filed by them in OS number 398 of 2022. Now, permit me to state that two basic facts. Otherwise,
Then what is this, OS number 1150?
that we have filed, my lord, my clients have filed. It's appellants 1 and 2 herein. Have filed OS 1150 of 2022, seeking a permanent, on our decree of permanent action, the respondents, defendants here.
This suit, this first suit filed by them is also for injunction.
Injunction, no, that is, my lord, for declaration,
Declaration injunction, yours is only injunction.
permanent injunction. one.
Uh,
Yeah. Now, basic facts are these. The first and
No, no,
second,
1 minute. No, in that, in MFA 2046, 2085 and 2091.
2051 and 2069 arise from OS 398 of 2022.
2069 and 2051.
20, correct. 2069,
Arises from OS number 398.
398.
Then
The
what's
rest
the,
arise from our
what are
suit.
the three applications in OS number 1150?
That is same, my lord, similar players.
But you have one more application, three.
Three applications filed.
One is injunction, one is
All
from
are injunctions,
operating.
all are injunctions.
Yours is all injunction.
One is not same, similar prayer, not to interfere with the administration,
One,
not to collect donations, not to interfere.
not to bank out.
Collect donations in the name of the trust.
Hmm.
That is one, second application. Third application is not to make use of trademarks of the trust, trademark and copyright of the trust. These are the three applications which were rejected. Now, basic facts are, your lordship may see the cast title. There are 6 appellants.
Oh, it is the case that where the daughter, wife and, is that the case?
Correct, same case.
Hmm.
At page number 5, Lord, your lordship would get the cast title. Please take 2051. That is the my lord leading case. Because all the documents have been filed.
2051.
51.
2051.
I will not take much time, my lord. I will complete my submissions.
Yes.
Here, my lord, here, there are 6 appellants. Your lordship is at page number 5 in the cast title.
Page number 5.
Yes. 6 appellants. Appellant number 1 and appellant number 2 are related. Appellant number 2
5
is,
appellants only. 5 only
one,
appellants.
my lord, there is an amendment subsequently as per the direction made by the court.
So 6 appellants.
6 appellants.
Hmm.
Because there was no order against the 6th appellant, she was omitted. Thereafter, the court said,
Oh, yes, yes, it's written here. Yes.
there, my lord, the first appellant is the son of the second appellant. Siddhant is the son of Arundhati Rishi Prabhakar. Now, Rishi Prabhakar, father of the first appellant and the husband of the second appellant, created a trust in the year 1982. That are given the details, my lord. On 6/2/1982.
6/2/1982.
By investing his own amount, by putting his own amount in the trust.
6/2/1982.
At page number 8, your lordship would get the date. What are the, my lord, objects I have stated, my lord, in page number 8, last few lines? The objects of the trust, your lordship got the, my lord. Because this is common to all the appeals. Once if your lordship sees one appeal, that is sufficient.
Yes.
At page number 8, the last 4 lines, the objects of the trust. Lordship got that, my lord. Originally formulated are to re-educate the public in science, technology of rishis, to bring perfect health in the society, to bring about mental, intellectual potential hidden in every individual and similar matters. Now, this trust is named Rishi Samskriti Vidya Kendra Trust, RSVK in short. This is the name of the trust. There, my lord, regarding trustees, your lordship would find, my lord, the relevant class at page number 9 of the appeal.
Yes.
They have produced documents also, but your lordship may see this. In class 7, subclass 4 and 9, I have extracted that. Class 4 of the trust deed. The trustees can also co-opt other members as additional trustees or ad hoc purposes. This one. Next, the appointment of the trustees, this 9, the appointment of the trustees mentioned above is for life. However, it is open to the trustees to resign their offices if they so desire. The vacancies cast in the office of the trustee shall be filled up by the remaining trustees by appointment of suitable persons. All the vacancies thus might arise from time to time in the offices of the trust shall be caused to be filled up by appointment of suitable persons by the remaining trustees for the time being. The co-opted trustees or ad hoc trustees, however, shall have no power in the matter of filling up the vacancies. This may not, these are the original clauses in the original trust deed.
Yes.
Now, the author of the trust, Rishi Prabhakar, appointed 6 trustees. One of them was his own mother, Ramadevi, who was the original trustee among the 6. Thereafter, my lord, there is second supplementary that is not relevant for our purpose because it's for income tax purpose. Then there is a second supplementary. Read. This is dated 28/9/2011, which was executed during the life of author of the trust, Rishi Prabhakar. He was alive till 2014. Now, this class 4 remained intact. Class 4, my lord, in the original trust deed remained intact. Class 9 of class 7 has been amended. Your lordship will get that page number 11. The appointment of the trustees is for lifetime. Then there is an addition. Unless the founder, Rishi Prabhakar, or his successor decides to change any of the trustees. The rest is same. The same as it is, it continues. Only this Milad clause is inserted here. That is, authorizing the author of the trust to remove any of the trustees or his successor to remove the trustees. This is the clause. Then, my lord, on 1/3/2014, the author of the trust, Rishi Prabhakar, expired on 16/2/2014.
16 to?
16th February 2014. He himself, while alive, he made a request for appointing his wife, the second appellant, as a trustee. Accordingly, with effect from 1/3/2014, the second appellant was appointed as a trustee. A document was produced in the trial
That
court.
is after the lifetime of Rishi
Correct.
Prabhakar.
After he died, author of the trust. The resolution is dated 24/2014. It says Srimati Arundhati is appointed as a trustee with effect from 1/3/2014. Then, my lords, she has been authorized. I have stated, my lord, the documents. She was authorized to operate bank accounts of the trust by various, my lord, resolutions. I have referred to them. And Ramadevi, my lord, mother of the author of the trust, Ramadevi, who was the original trustee, expired in the year 2021. Last time I submitted 2019. Actually, my lord, it's 2021, February. April 2021. Thereafter, my lord, it was noticed that the 2 trustees which were there in the trust, the rest, my lord, either resigned or they were dead. There were only 2 trustees at that time. They were misusing, my lord, the properties of the trust. Therefore, by resorting to this clause, my lord, the clause which has been amended by the second supplementary, that the appointment of the trustees is
Where
for
will you
life.
get that?
Pardon?
Where will you get that?
Page number 11. Extract. The appointment of the trustees is for lifetime unless the founder, Rishi Prabhakar, or his successor decides to change any of the trustees by making use of this. Since it was not disputed that, my lord, the first appellant and second appellant were the successor of the late Rishi Prabhakar, executed the third supplementary deed, whereby the 2 trustees who are, my lord, plaintiffs 1, 2, and 3 in OS 398. The first plaintiff is the trust. Individual trustees are plaintiff number 2 and 3. They were discharged from the trust as trustees. Now, OS 398 has been filed by the discharged trustee.
Who was discharged? Respondent herein? What is the name?
Your lordship, your lordship would get me the plaint at page number 86
Hmm.
in that OS.
No, I'm looking at the cost title here
Yeah.
itself at page number 6.
Satyanarayana, Sri Satyanarayana.
Satyanarayana and Ramesh Chandra.
Correct.
You have removed these two.
They were discharged.
Hmm.
Discharged. And
When was it?
that was in 2000. 23/11/2021.
Hmm.
All these trust deeds are registered. Supplementaries are also registered. They were discharged. Now questioning this, questioning the third supplementary whereby they were discharged, they filed a suit. The Satyanarayana and Ramesh Chandra filed a suit in OS 398 of 2022, questioning the third supplementary and seeking a declaration that it's null and void. Because according to them, we did not have power to remove them from trusteeship. The second query is for permanent injunction. In that, my lord, I submitted 2 IAS were filed for grant of temporary injunction against us in respect of administration, in respect of operation of the bank accounts.
Those were granted.
It was they were rejected earlier. Those 2 IAS were rejected by the trial court. Against that, my lord, against those orders, these persons, my lord, came up before in appeal before this court. This court allowed the appeals and granted temporary injunction. Against that, my clients went to the Supreme Court. Supreme Court, my lord, after hearing all the parties, set aside both the order of the High Court and the trial court and remitted the matter to the trial court for fresh consideration and disposal. There, my lord, I have submitted that in respect of appointment of Arundhati, 4 documents were produced. 4 or 5 documents were produced before the trial court. In the order, there is no reference to those documents at all. There is no mention, no reference. There is no indication of consideration of the said documents. Those documents were produced, my lord, along with the memo. Last time, my lord, while hearing the matter, your lordship wanted to see that it was not traceable in the file. Therefore, I provided an additional copy. Kindly see that.
So before going into that,
It was filed
let us just go to the order so that the court will understand what is, on what basis this is dealt with. Then we'll look at the documents.
Yeah. Your lordship got that, my lords, memo with the documents filed in the court on 18/4/2024. Additional copy I have provided on the last occasion.
In which case you have filed?
2051.
No, 2051.
Yeah. I don't know whether it's stitched, my lord, or not.
16/7.
No, this is 18/4. Last time I provided an additional copy also when the matter was heard, since it was not traceable.
15/4
18/4. Madam, court officer. One separate copy ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
Not there.
Can I pass on one more copy, my lords?
Yes. Before that, we'll read the order and then we'll
Yeah,
go
yeah.
to the other thing.
Yeah. So I submitted, there is no reference to these documents. Take 1 minute. One more copy I'm providing of those documents. Good. I submitted that. Those documents, there is no reference in the entire order. But I will, I may permitted to read only the relevant portion, not everything. It starts from para 15 minutes in the common order under appeal. At page number 38 in appeal to 2051. I read minutes.
Yes.
On going through the pleadings of the parties and the materials on record, the parties to the proceedings are at dispute based on the third supplementary date of the trust date dated 23/11/2021. The plaintiffs in OS 1150 of 2022 claim that they have taken over the affairs of RSVK Trust in terms of the trust deed, and they have reconstituted the trust by discharging defendants 1 to 3 therein from the post of trustees. Whereas the plaintiffs OS 398 of 2022 has disputed the competency of the plaintiffs in OS 1150 2022, either to remove them from the post of trustees or to reconstitute the trust. Thereby, the plaintiffs in OS 398 as well as the defendants in OS 1150 have contended that the third supplementary deed of trust dated is a fraudulent and document. Based on these contentions, the plaintiff in OS number so and so and the plaintiff in so have maintained relevant applications seeking ad interim orders of injunctions in connection with the managing of the affairs of the trust. Undisputedly, both the parties do these proceedings rely on class 711 of the second supplementary deed of trust in support of the contentions. Your Lordship has read that, my lord, that portion. Your Lordship, my lord, I can read it again if necessary. At page number 39, bottom portion.
Yes.
Appointment of trustees is for lifetime unless the founder Rishi Prabhakar or his successor decides to change any of the trustees. Only this much is relevant for our purpose. Admittedly, para 17 minutes.
Yes.
Admittedly, the founder namely Sri Rishi Prabhakar had not decided to change or remove Sri Satyanarayana Kya H.S. Ramesh Indra from the post of trustees in RSVK Trust. He passed away on 16
However, his mother, C.A. Ramadevi, passed away on 19th April 2021. Therefore, his wife, Arundhati Rishi Prabhakar, and his son, Mr. Siddhant Rishi Prabhakar, are the only existing legal heirs who will be the successors to the late author, Mr. Prabhakar Raghavendra Rao, alias Guruji Rishi Prabhakar, and the legal heirs have obtained heirship certificate, and this is approved by the judgment and decree of so-and-so, Aurangabad, and so-and-so, on 17/4/2018. Additionally, attested family tree certificate so-and-so issued by Revenue Department, Government of Karnataka on
So in this, there is no mention about her being, she being appointed as a trustee. in
There is no
2014.
reference.
That's what the reference is,
I admit,
that she
in
becomes
this
a
third sub-
trustee.
one
One moment. The reference, my lord, is that she has obtained an heirship certificate. She becomes a successor under Hindu law, Hindu Succession Act. That is the reference.
I have a meeting at 5 o'clock. The poses matter on Wednesday at 2:30.
Next Wednesday, my lord.
Part heard.
Maybe. Great.
In this, that the Supreme Court judgment and this court judgments are also there.
I have five.
It's there, my lord.
In my compilation, I have.
On submission, Lordship, serial number 17 matter, Lord. Interim order may be extended.
Why are you coming now?
I forget that.
Huh?
Trial court file kodi. There are in compilation.
I will, from here onwards, I'll not do all that. Now, what is, it's a punishment for them. All the matters that are over again, they have to take it out.
I applaud him. Lordship.
17 in what? In which list?
List number 1, Lordship.
It is like complete in the morning itself.
No,
Which one? Yes, interim order extended to the next day.
Applause, Lordship.
One
Same.
submission.
Serial number 42, madam, same. Interim order may be extended.
Yes. December 16th and 17th. Yes.
My Lordship, one submission, serial number 48, final hearing, my Lordship. Kindly have it after vacation.
Yes.
But in 49, I appear for respondent for the petitioner. Have it next week, any day, my lord.
After vacation. I should go. Yes.
ಮೊನ್ನೆ ಹೇಳಿದ್ನಲ್ಲ 17 ಅವ್ರು ನೀವು ಹೇಳಿದ್ರಿ ತಗೊಂಡಿರೋರು ಇಲ್ಲಿಲ್ಲ ಇವರೆಲ್ಲ ತಗೊಂಡಿದ್ದು 42 ತಗೊಂಡು ಬೇರೆ ಅವ್ರು ಗಮನಿಗೆ ಏಪ್ರಿಲ್ ಅಂದ್ರೆ ಯಾವ್ದೋ ಬೇರೆ ಕೋರ್ಟಲ್ ಹಾಕಿದ್ರೇನು ಏಪ್ರಿಲ್ ಅಂತಾರೆ ಏಪ್ರಿಲ್ ಕೇಳಿದೆ
42 ನಾನು ಅಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಬೇರೆ ತಗೊಂಡಿದ್ದೆ
ಅರ್ಥನೇ ಆಗಲ್ಲ
ಬೆಳಗ್ಗೆಯಿಂದ 3 ಜನ
ನೀವು ಒಂದು ಎಂಟ್ರಿ ಮಾಡಾಳದು ಯಾವಾಗ ಹೇಳ್ಬೇಕು ಚೇಂಜ್ ಆಗ್ತಾರೆ